Good afternoon and welcome to the First Department Appellate Division. We have a full calendar today and have about 6.5 hours of requested argument time. So I see smiling faces. You guys already know what I'm going to say. So please ask for the time that you need, not the time that you want. Understanding we are fully familiar with the facts, with the briefs, with the record, usually more than you wish we were. Okay? So, and understand that the clock is for you, not for the court. So if my colleagues have additional questions beyond the light, I let it roll. All right? So if you're brilliant, it keeps going. Okay? All right. People versus Juan Perez. Okay? All right, 6 and 2 and 5. Nazer versus Sydney Soul Group. Okay? All right, let's do 6 and 2 and 5. Forgive me if I butcher names, okay? Abramov versus 230 PAS SPE. Okay. Okay. All right. I like the last one. 5 and 1, 3 and 2. Salama versus Grabowska. Okay, you have no opposition here, so give me another request because I'm not giving you 10 minutes. I'll give you 5. Thank you for working with me. Charles Condominiums versus Victor RPM First. Okay. 6 and 2 and 3. People versus Manuel Vega. Okay.
Respond to request 5 minutes, please.
All right, I'm going to do 7 and 2 and 5. The question may get you to 8 anyway, all right? Kawa Seni Company versus Anna Aircraft.
Good afternoon, Your Honor. The appellant requests 8 minutes and 2.
Okay, we're doing them both together. All right, and Anna Aircraft?
A&A Aircraft would request 10 minutes.
Okay, so we're going to do 6 and 2 and 7. And again, questioning may take you over that time. CUCS Housing versus Ames. And? 4 and 1 and 5. Isali versus Guard.
Good afternoon, your plaintiff request 9 and 3.
Okay.
Good afternoon, Your Honor. On behalf of, we have 2 respondents. I'm representing respondent guard, so we would request the same amount of time.
Do you have a cross appeal? So you don't get rebuttal time. How much time would you like?
We could do 12 minutes.
All right, you guys were not listening. You weren't listening. So how much would you like, sir?
2 minutes, Your Honor.
Okay, so we've got 7 and 2, 4 for Guard, and 2, you are for? You're for Burke, and 2 for Burke. Okay. Lopez versus NG 645 Madison.
Good afternoon, Your Honors. Representing the second third party defendant, appellant respondent, I request 6 and 2, please.
Okay, how much?
6 and 2.
Okay.
Good afternoon, cross appellant respondent, 4 and 1.
You're Zerum?
I'm Sarah, Your Honor.
You're Zerum.
NG and Neil are
You, okay, and you're asking for how much?
4 and 1.
Okay. All right. Good afternoon. All right. All right. So we've got NG 645, 5-1, Zerum, 5-1, plaintiff 3, and third-party defendants 3. Okay? Skyview Capital versus Conduent Business.
Afternoon, Your Honor.
Good afternoon.
Request 8 before.
Okay?
Skyview Capital, Your Honor, I'd like to introduce my colleague, Pat Abbott from Pennsylvania, who is arguing with permission. We're responding and cross-appellant, we would like 8.
All right, so there are cross appeals? Okay, so the Pro Hoc Vici application is obviously granted. Welcome. And we will have 8-2 and 8-2. This one's a beefy one. Gillard versus Citigroup is a submit. Anheuser-Busch versus BBSR LLC.
Good afternoon, Your Honor. On behalf of the appellant BBSR, we request 5 and 3, please.
Okay?
On behalf of the respondent, we request 6.
Okay, 4-1 and 4. We usually don't grant argument at all on those cases. First case on the calendar, People versus, I'm sorry? Oh, Windward Bora is also a submit. First case on the calendar, People versus Juan Perez. You may proceed.
Good afternoon, Your Honors, and may it please the Court. Stuart Gold on behalf of the defendant appellant Juan Perez. This appeal concerns whether the people disprove defendant's justification defense beyond a reasonable doubt. Defendant,
Have you ever heard the expression, picture is worth 1,000 words?
yes.
Have you ever heard the expression, a video is worth 1,000,000?
Yes, and I understand that,
So when you look at the video here, do you think that that video, in any of its angles, would somehow show that what this defendant did here was justified?
yeah, so, in all these types of cases, if you look at it in hindsight, and if you look at it from a video, it doesn't give the complete picture, and it's hard to,
So what in the video somehow was left out?
right, so, defendant was dealing with a very erratic individual, Burham Husinaj. He was highly intoxicated.
Which is what police officers do on a daily basis, 24/7 in this city. This is not a unique circumstance dealing with an inebriated person who is also emotionally disturbed, which adds a added level of required tempered response when dealing with that particular population. So explain to me, based on what is clearly visible on this video, how this officer was in fear of his safety at the moment that he punches this person in the face 6 times in rapid succession.
Breaking his nose.
And I would just add that, as reflected in the videos, his partner was now present. He was no longer being held by the person who was on the ground. And then that person who's on the ground gets punched in the face 6 times.
And his nose is broken.
Sure. So I'll start at the moment right before the actual physical altercation began. So
Is that the time when he was sitting in the chair talking about he has magic fingers?
right. So a minute or so after
That warrants someone getting punched in the face?
no. I mean, the totality of the circumstances certainly plays a role. But at one point, when Husinaj disobeyed one of the orders given by defendant, defendant asked Husinaj to put his arms behind his back and tried to arrest him. Then Husinaj resisted arrest, tripped defendant to the ground, took an arm, placed it tightly around defendant.
Tightly
Okay.
around?
Okay, and then his partner came and removed the arm, at which point there was no more danger. Again, we want to know at what point did the police officer feel that he was in danger?
Right. So he was put in a tight 3
He
second.
was not put in a tight. He wasn't put in a headlock. He was not put in a headlock.
The person on the ground's hand was extended. I don't know, that's not how you do a headlock, right? That would be
I mean, headlock, I'm just saying his arm was around the back of defendant's neck, a neck restraint, if you want to call it. And it took defendant's partner 3 seconds of pulling on Husanaj.
And you know what's interesting about those 3 seconds? Because even then, that wasn't the point when the officer punched him in the face 6 times. It was when his partner had now released him, he moved back a bit and then punches him 6 times. So that's more retaliatory. That's not justification, right? Because you're not doing anything to prevent further harm to yourself because the harm has been alleviated.
Right, but we're talking about 3 seconds. So within 3 seconds after Officer Breyer, which was defendant's partner, was able to pry off Husanaj's arm from defendant's neck, defendant threw 6 punches at Husanaj. Now, what's critical is that
Counsel, just refresh my recollection as to the timing. I thought it took 3 seconds to remove the arm from the chokehold as
It
opposed
wasn't a chokehold.
to 3 seconds.
I have to stop because it wasn't a chokehold. A chokehold requires a complete lock of the head inside a folded arm that is in a V. That's not what is depicted in this video.
I didn't refer to it as a...
I did.
Okay, the record has to be very clear because if it were a chokehold, we'd have a different situation.
So, counsel, the 3 seconds refer to the amount of time that it took to remove the arm as opposed to the amount of time between the lapse between the removal of the arm and the punches. Am I right?
So there were 2 3-second periods. It took 3 seconds for Officer Breyer to remove the arm from defendant's neck. And then within the next 3 seconds, that was a period when defendant threw the 6 punches.
So, in viewing the 4 different videos of the incident, it appeared that the officer was straddling the person's body, right?
The officer was what?
The officer was straddling the complainant. He was atop him.
Right. So right after the neck restraint was freed, Officer Breyer had both of his arms on Husanaj's left arm, and defendant had one of his arms on Husanaj's right shoulder. And Officer Breyer, who was the people's key witness, he testified that the threat posed by Husanaj didn't end until after the 4th punch. Specifically,
So there's a separation in the there's testimony that there's 4 punches plus 2.
right. So Officer Breyer testified that the first 4 punches, the threat posed by Husanaj was continued, and the reason was because Officer Breyer felt tension in Husanaj's arm. So Husanaj was resisting being subdued.
Counsel, you just stated that the partner took one of his arms, correct? The victim's arms,
Yeah, right.
had one arm, and that this drunk victim only had his other arm on the officer, correct? On his shoulder, correct?
The defendant had his left arm touching.
Okay, the defendant here is your client. I'm talking about the victim that was punched in the face 6 times, okay? You just stated that his partner took one arm away, right? Held one of the victim's arms, and that the victim had the other arm on the officer's shoulder. You just stated that, correct?
Yes.
Yes?
You just said that.
Sorry, the defendant had one of his arms.
We're confusing
Counsel,
the defendant.
The
Your
defendant is your client.
client, the police officer is the defendant here. The
Right.
victim is the guy punched in the face 6 times with the broken nose. You just stated that the defendant's partner held one of the arms to the
Correct.
side, correct? And that the victim then used one arm to touch the officer's shoulder, correct?
I misspoke then. The defendant had his left arm on the victim's right shoulder and used his right arm for the punches.
A crossover?
Where was the danger to the officer in that situation that he had to punch him 6 times?
Was that-
Where the guy is drunk, one arm is restrained, he only has one arm. Where is the danger to the officer?
Because he was resisting being subdued. Officer Breyer testified.
Resisting is not a danger. Those 2 things aren't equal, right? For which you can get punched in the face 6 times.
Well, Husanaj was a very, this was a tragic case, but he was, intoxicated, erratic, and he just put
So,
my
all
client
right.
into a neck restraint, and he was still even after the first punch, as Officer Breyer testified, he was still resisting. He was trying.
There was no hesitation from the first punch to the sixth. Please don't tell me, okay? Please. Don't try to argue that there was any thought process other than, I'm angry that you didn't cede to my authority, and so I'm gonna punch you in the face. Please, you'll have time on rebuttal.
Good afternoon, Your Honors, and may it please the court, Jennifer Mitchell for the people.
Well, counsel, let me ask you this question, because the radio run alluded to an erratic person, right? That's how the 911 phone call came through, and the radio run reflected that this person was on the street yelling at other people, had a bottle raising above his head as appearing to try to assault people. So this is what the officers are walking into, which you can agree is a heightened situation.
Absolutely,
right?
Your Honor. No one's disputing that.
And then they approach this individual, and he is obviously drunk, talking about God and magic fingers, that he's God, magic fingers, maybe emotionally disturbed, right? And not following the officer's directions to just sit there and wait for the bus, which we know was an ambulance, to come. And he keeps getting up and things like that. At that point, why isn't the officer entitled to be on some kind of heightened alert status? And then he winds up on the floor with this person's hand on his shoulder, neck, or someplace else.
Your Honor, I think the answer is very simple here. Some force was justified in this situation. Again, this was a heightened police encounter. However, the point is the sheer amount of force that was used was disproportionate to any possible threat that may have existed during this interaction with the police officer. 6 punches was just simply disproportionate to any possible threat Husanaj may have posed to the officer.
Well, I imagine then that's why they try to distinguish between the first 4 punches, some 3-second delay that I don't know, may or may not exist, and then the 2 later punches. Those 2 later punches maybe not being justified, but the 4. Is that a distinction without a difference?
Your Honor, our position is that none of these punches were justified because, as this court has made clear, by the time the first punch was thrown, Husanaj was already pinned down on the ground and his other arm was being held by Officer Breyer, and there simply no threat existed at the point when the first punch was thrown.
There's a question, counsel. If one arm is restrained, that means the other arm is free. Did that free arm pose a threat to the officer?
I don't believe it did, Your Honor.
Why not?
Based on the video that we have and from what we can see in the different angles, defendant was completely on top of Husanaj while they were both on the ground at this point. It's unclear where exactly the other arm was, but it's hard to imagine that he could have posed any type of harm to the officer.
Was that other arm at all visible at any point from any of the 4 different videos that were submitted? Is that arm visible in any of the videos at this particular point in the interaction?
No, it's not, Your Honor.
There was a suggestion in briefs that the free hand could be used to go for the officer's gun.
There was
there any, even a scintilla of evidence that was the case here, that this young man who's drunk and going through an emotional disturbance episode, obviously, that he at all attempted to use that free hand to go for the officer's gun?
There was absolutely no evidence to show that, Your Honor.
And we can see in the video that the officer is prone, above, and sitting, pinning down this complainant. Am I wrong about any of my observations?
No, you are not, Your Honor. That's exactly correct.
Counsel, when the people made a motion to dismiss at the end of the people's case in chief, did they specifically address the inadequacy of the evidence at trial?
Did defense, Your Honor? They did not. So part of our argument is that their legal sufficiency claim in this case is unpreserved because their motion that they made was not sufficiently specific and detailed to the justification defense that they're now raising on appeal. If there are no further questions, then we ask that you affirm.
Thank you so much. You have 2 minutes.
Thank you. Regarding the sufficiency of the evidence, what matters is whether the trial court was presented with the argument that's presented on appeal and decided it. This whole case was about whether defendant was justified, and all the arguments that were advancing on appeal was raised in summation and opening throughout the trial, and the people acknowledge this. And even if sufficiency of evidence claim was unpreserved, there's still the weight of the evidence challenge. I'd like to just read to you Officer Breyer's testimony, and this is on the transcript on page 92. So Officer Breyer, after the fourth punch, that's when he said, "Stop, stop," to defendant. He was asked, "I believe you said stop, stop, correct?" "Yes." "And that was because you envisioned that the threat was over, correct?" "Yes." "There was no tension in Borum's arm anymore." So we have the people's own witness testifying that the threat by Husinaj still continued until after the fourth punch.
We also have voices in the background of the video, observers, community members who are heard saying, "Oh man, you didn't have to do that." So should we consider all of that?
Well, I mean, so there were also bystanders who said that defendant was justified in what he did, but
Really?
yeah, I just
Which
didn't.
video?
It was in the body-worn camera video. Is that,
So, counsel, there's a point where the defendant speaks to some people who are across the street, and they come over, and he asks them if they would speak up on his behalf.
make a statement, correct?
Do we have any statements from those persons?
There are. I just didn't. I mean, I didn't think what bystanders believed was really relevant to the issues here. I thought most
Well, then,
important is
I'm glad that you said that, because the fact that they said that he was justified isn't really relevant, right? Because we have this video
Right.
that speaks for itself.
Yep.
I'm sorry. Say it again.
You just said that you didn't want to go into what my colleague was asking you about because you didn't think that bystander's belief was relevant. So your statement about people saying on the street that he was justified in doing that, that's really not relevant to us, because we have a video that kind of goes against, not kind of, goes against what it is that you're trying to posit here.
No, what I'm trying to say that's a legal conclusion whether someone was justified or not, and
I agree.
People were saying he's justified.
We
and-
agree that all of the comments on the outside of the video of people observing is just that, just opinions.
that defendant was justified.
They're just opinions
Right, of course. And
by
so-
lay people. Thank you so much for your argument, sir. Nazer versus Sydney Soul Group.
Good afternoon, Your Honors.
Took him a little while to get out of the row. You may proceed.
Thank you. It pleased the court, Bruce Wiener for the appellants. Ms. Nazer has been residing in this building for 42 years, and Mr. Mickle, 29 years. In the lower court's sweeping order that granted summary judgment dismissing the entire complaint, the lower court committed several significant errors that are pointed out in our brief. The court first relied on a long-expired commercial loft lease in dismissing several of the causes of action. This reliance distorted the lower court's analysis of several of the causes of action. Sham commercial leases in loft cases have never been found to be dispositive by any court. They were just that. They were commercial leases that were a cover for what the landlord wanted to do in having people reside in those buildings and pay rent when they did not convert them legally to residential use.
One question, counsel.
Yes,
With
Justice
respect to
Gonzalez.
the obligations that were set forth in the commercial lease as to repairs and maintenance, is there any special treatment or disavowal of those kinds of responsibilities taken on by the tenant?
Well, the courts look to the actual tenancy. If it's a residential tenancy,
then the breach of warranty of habitability by statute applies. So the tenant, even though a commercial lease normally says that the commercial tenant is responsible for fixtures and repairs, that is undone by the legislature in enacting the warranty of habitability. It's clear that it's the landlord's responsibility when it's a residential tenant to make repairs, and the court should not have relied on those provisions of a 1983 lease that expired decades ago. And Nazer and Mickle have been found to be residential tenants by several courts and by the loft board. So it's clear that they're not commercial tenants, as the lower court found.
And therefore, the standard would be different as to warranty of habitability?
Absolutely, and as to retaliatory eviction, as to the harassment statute, all of these things apply to residential tenants, and they are residential tenants. Even in the recommendation from Oath that they attached to their brief, the court found that they were both residential tenants. The court found that this time around that they were somehow living together, which is directly opposite of the finding of a prior ALJ at Oath that they were living apart. So,
Things change, though.
well, they didn't change here. Because the landlord argued that Mr. Mickle was living in his office downtown. They didn't even argue that he was residing with Ms. Nazer in her loft. So it's exactly opposite. So that hasn't been reviewed yet by the loft board. They have a chance. It's not a final determination. It's not a decision. It's a recommendation. So it has no bearing on this appeal.
Would you reflect on the windows for 1 second in this context? The repair or the replacement of the windows, which were part of the responsibility of the tenants under the lease?
It can't be. I mean, the windows have been non-functional for decades now, since the action, before the action was commenced in 2008.
And the landlord actually repaired other windows in the building, just not those windows.
Well, the landlord had a mostly residential building at one time. He was able to, because the loft law originally didn't apply to this district, he was able to evict everybody but these last two tenants who have been fighting him since before 2008 to stay there. And the second major issue to get to is that the lower court mistakenly viewed court-ordered use and occupancy without prejudice as voluntary rent payments.
And clearly, the case law does not support that.
And this court, in fact, set the UNO.
Yeah.
I argued it. And I had a question from the late Justice Abdus Salam, and I conceded what she asked because she was right. So the UNO that had been found by the lower court was raised slightly because that's what the pleading said, and I admitted that. And so the rent was raised to $4,773.25 in 2013 by this court. And since 2008, and there was a prior order directing $15,000 a month. And in a prior appeal in 2011, this court said that's ridiculous, remanded it to the late Justice Feynman. Apparently, it's a lot of late judges who had this case. But Justice Feynman found that the rent was a little bit lower than the $47.73, but this court said it. And each and every month since 2008, these tenants have paid that amount each and every month. It's not voluntary rent payments, as the lower court found. It's use and occupancy without prejudice, and there can't be a statute of limitations applicable to court-ordered UNO payments without prejudice, because then the length of the litigation itself would dictate whether you could claim that you could get money back. And in fact, when this court lowered the amount from originally from $15,000 and remanded it, and the final amount was the $47.73, the landlord was forced to refund the overpayment. So that shows that there was no expectation that this was voluntary rent payments that he could keep. So the lower court was completely wrong about those issues.
All right, you'll have
And many
time on
others, but-
rebuttal. We've
I'll
gone
get
way
to it
over that
again.
red light, and I gave you some grace.
Thank you very much.
All right. You may proceed, sir.
Thank you, Your Honors. If it may please the court, my name is Jason Frosch of Windows Marks Lane in Mittendorf for respondents.
Counsel,
Counsel,
would
can
you,
you pick, I'm sorry, go ahead.
I think we might have the same question, just in terms of the use and occupancy. There were court orders that
Yeah,
ordered that?
there's a lot of confusion here. No one's disputing this. The cause of action in this completely separate action, this is a totally separate action. Mr. Wiener's talking about a 2008 action. That's not this action. This is a 2019 action with totally separate causes of action. If there's a use and occupancy order in a different case, and that case is still pending, and that order is still in place, they have the remedies to try to do something about that order.
So you're saying that now in 2019, it switched back from use and occupancy over back to rent?
No, what I'm saying is the cause of action in the complaint, I took it right out of the order. From the commencement of plaintiff's tenancies, the building's not had a C of O pursuant to MDL 302, that's invalid, I'm paraphrasing. And then it says, plaintiffs are, and this is exactly the quote, plaintiffs are entitled to recover all amounts unlawfully collected by landlord as rent or use and occupancy from no less than 6 years before the commencement of the ejectment action. The ejectment action was commenced in 2008. So according to what was actually pled, this seems to be a claim for rent or use and occupancy from 6 years prior to 2008, which is time barred, which has nothing to do with interim use and occupancy pendente lite orders in the 08 case. And when it was argued, the appellants didn't really make it very clear in their briefs that they were specifically talking about use and occupancy orders. Had they, the cause of action would have been dismissed for prior action pending, for failure to state a cause of action. You can't collaterally attack a pendente lite use and occupancy order in a separate pending action in your own cause of action in a different case. Doesn't make any sense. They kept it ambiguous
And
intentionally.
what case law says that?
I'm sorry?
What case law stands for that proposition?
There's no case law in favor of the position that the appellants are articulating.
That wasn't my question, right? My question was, what case law stands for the proposition you just made?
I may have
So
cited
you
some
have
in my-
none.
I don't remember. I may have cited some in my brief, but how can a court...
Amazing. I think you would have had that case on that little piece of paper if you had one.
Just as a matter of procedural common sense, I can't sue in a brand new action to try to disturb a pending pendente lite order. If there's a preliminary injunction order in one action, I can't sue to try to invalidate or otherwise disturb that pending interim order in that other case. Their CPLR requires me to attack an order that's pending before the judge that signed it in the action that it was signed in. So I'm sure that I have case law talking about the CPLR provisions involving this, but it's not my burden, it's the appellant's burden. And we're talking about the first two causes of action, but there are 12 causes of action here, all of which were dismissed based on being time barred, based on being improperly pled, based on relying on some determination that this is a loft building. There is no determination. This is a commercial building in a manufacturing district. There's never been any determination that it's residential or that it's covered under the loft law.
Proceeding as far as what their status is?
We annexed the determination.
That's a simple yes or no. Is there a pending proceeding on the status of that action?
Whether it's
Counsel, answer the question.
no and yes, because it's not pending. The trial is completed, and the factual findings were rendered that there was no that the appellants didn't satisfy their burden, so their claims were dismissed. Now that's pending a review and approval or denial by the loft board. So it's not the trial's
Oh, it's
over.
on
The report.
appeal?
I'm sorry.
It's on appeal before the loft board?
It's almost like a hear and report. So the referee officer, in this case it's Oath, did a full trial and issued a full report and findings of fact, all saying that the burden wasn't satisfied
No,
for
my
this to be
question
lawful.
was is it on appeal, internal appeal within the loft board?
Right. So it's not a final determination
So
by the
at
law
this
board.
point, use and occupancy is being paid?
It has nothing to do with the use and occupancy. I mean,
I'm just asking you, counsel, if you would just tell me.
It really would help. It really would help if you just, we appreciate that you have arguments you want to make, and we want to give you the room to make them, okay? That doesn't mean that you get to not answer our questions.
I'm answering-
Our very direct
I'm
questions.
answering to the best of my ability whether it's pending is in dispute.
No, counsel.
I'm articulating
The
that the-
question, my present question is use and occupancy currently being paid?
yes, as far as I'm aware, as of a few months ago, yes.
Okay.
But that's, again, it's in the 08 case. It's not the 2019 case that's before us. Appellant has not explained why they're entitled to bring a cause of action, by the way, that's styled as rent overcharge. This is a use and occupancy order ordered by the court. Why is the appellant entitled to maintain a cause of action for an accounting of the use and occupancy? There's no case law that supports that this
Is
is
it for
being
the
held.
use and occupancy or for the security deposit?
Well, I guess it's interpretable as two different things, right? So the thrust of their cause of action,
But if they gave a security deposit, would they not be entitled to an accounting as to see what happened to where that money went?
that's not, so what the lower court found is that they didn't establish any fiduciary obligation regarding the UNO, and then as to the security deposit, they submitted no evidence after this was done post note of issue.
Is there a security deposit being held by the landlord?
I believe so, I don't know.
How much is the amount? What is the amount of the security
don't
deposit?
remember.
Know what the
I
security?
don't remember because on summary
The
judgment.
counsel, if you're pointing these things out, how do you not know?
This was a summary judgment motion in which it was the appellant's burden to show that there was some misappropriation or commingling or failure to make an accounting.
Okay,
And they
thank
failed
you.
to show any of that.
Thank you so much. You have 2 minutes, counsel.
Would you answer my question, counsel? Is there a security deposit and in what amount, please?
There is, and I believe it's in the 4,600 amount. But
So
I'm
is
not
this-
exactly
is
certain
this
because it
appeal-
goes back to the 1990s.
Is this appeal before us strictly about that?
No, it's about the use and occupancy payments and the security because the landlord, there has to be an accounting. If this court had ordered in 2013 the reduction of the UNO and the landlord had to pay it back to us, the same thing is still pending. That's why a new cause of action was asserted in this case as it had been in the 2008 case because we didn't want anything falling through the cracks. You could rest assured, Justice Gonzalez, that if we stopped paying the monthly UNO, we would have been subject to ejectment immediately.
So are you saying that there's a balance owed to your client?
We are saying that at the end of the day, if the landlord is found not to have been legally able to collect rent because of the lack of a certificate of occupancy, then theoretically he would have to refund the entire amount.
Yes.
Based on breach of warranty of habitability, it's going to be some amount of the 4,600 that's been paid.
Your desire, your application is to know that that money is there? Is it as simple as that?
We don't want to give up the claim. The lower court dismissed that claim, which it shouldn't have done, finding that it was voluntary rent payments.
But I'm asking you what you want
We want a trial on that issue, ultimately,
on the issue of whether the money exists.
whether we are entitled to recoup any of the money. That's the cause of action. It's the same in the 2008 case. We've been paying since 2008. It's now 2025. It's a lot of money.
Thank you.
Thank you very much.
Abramov versus 230 PAS SPE. You may proceed.
Good afternoon. My name is Paul Golden. I'm here representing Arsenal Scaffold. All the documents, all the information indicates that the scaffolding company cannot be held liable in any way, shape, or form. They produced photographs showing that the joint expansion was exactly the same before and after. And all we have in response is speculation after speculation. Maybe it's this, maybe it's that, maybe it's the other thing. But of course, the plaintiff himself recognized that my client had no liability, was not to blame.
There were allegations that maybe there was improper lighting in this sidewalk shed. Did the plaintiff ever testify or indicate that there was something wrong with the lighting as to why this accident occurred?
As Your Honor told me, answer the question, he said nothing about that at all. He said it was a bright day, And he said there was no issue, he did not say any issue about lighting at all.
What was Arsenal responsible for providing the lighting under the sidewalk shed?
There's no indication that it was. The contract does not indicate that it was responsible for resolving lighting issues whatsoever.
Now you said that it was that the plaintiff testified it was light out, and this accident happened at about 12 p.m. midday.
No, noon.
Right, noon,
12
midday.
p.m.
I think you said midnight. That's
No, midday. So, and it happened right on the corner, not in the middle of the sidewalk, but right on the corner where if there's sunlight, it would be shining on this particular area. So lighting was not an issue.
correct.
Counsel, well, back to the lighting. In your brief, you state that the violation was resolved a month prior to the accident and that there was a certificate of compliance to establish that, correct?
Correct again.
Is that certificate of compliance in the record here?
It's on 460, I believe.
Thank you.
By the way, that certificate was, that violation was not issued against my client. It was against the general contractor.
And again, the plaintiff said nothing about the lighting.
That's absolutely true. It's not just the plaintiff that said nothing about it.
No one said anything about
There we
it.
go.
Did your client have any responsibility for the sidewalk whatsoever?
No, it had no responsibility with the sidewalk. It had no ability to cure any defect that had been existing there beforehand either.
So
we
was
have-
your, go ahead.
Do we have anything in the record to indicate that the existence of an expansion joint or the expansion of an expansion joint is attributable to the construction of a sidewalk or
No,
a
there's-
sidewalk shed? I'm sorry, not a sidewalk.
short
A
answer.
sidewalk shed or a scaffolding?
As I've been told, the short answer is best. No, there's nothing in this at all about that. I mean,
I don't care whether the answer is short or long, so long as it's an answer to the direct question,
that's
okay?
fair. That's fair. It's if we can bring, if I can bring a little bit of reality into this, of course, it's an expansion joint, meaning that, if it was, the weather affects it, certainly. That's what expansion joints are there for. Just to be, there's something just a little bit unclear about what the plaintiff said, which is he called it a crack a few times, but it was pointed out during the 50H hearing that when he said crack, what he really meant was the expansion joint. That's what he fell over. And there's no indication whatsoever from either of the parties who opposed the motion, indicating that that my clients had any ability, any relationship to that expansion joint, any
Get ability, did they have a duty to do anything other than put up the sidewalk shed?
No.
Thank you. Okay.
Good afternoon, Your Honors, and may it please the court. Ross Frischer for the owner, respondent. Here, the motion court correctly denied the subcontractor's summary judgment motion because it was premature.
Why?
The summary judgment motion was filed before any discovery at all has taken place.
What did your client point to that discovery would yield that would assist them in this motion?
Yeah, so it goes back to the fact that the plaintiff was not yet deposed, number one, and number two, that the
But what's at issue is what are the duties of this particular defendant, right?
right. So
So what are the duties that you believe or your client believes would keep them into this case after they've erected this scaffold, since that was the only thing they were contracted to do?
right, Your Honor, and thank you for the question. If they put up the scaffold, which they did, they could have either caused the defect that caused the plaintiff's injuries, or if
Well,
it
the
was a case
plaintiff certainly wouldn't help you in that, because the plaintiff wouldn't know what the condition of the sidewalks were prior to the erection of the sidewalk sheds. So deposing the plaintiff doesn't help you in that regard.
right, so that would be deposing them and to see if there was any, defect that
Actually, it
was
would be
created.
deposing your people,
I'm sorry?
right? It would be deposing your own clients, because they be the ones in the best position to know whether there was any work done on the sidewalk right in front of their premises?
No, Your Honor.
No?
Because, well, I'm representing,
an
I'm
owner?
representing the contractor, and we hired,
Okay.
the contractor hired the subcontractor to do the work, and to the extent that they did, which they did, they would have the knowledge of whether they caused a defect either by putting the poles in for the scaffold or some other.
Are you suggesting that a GC has a sub come and do work on site and they're nowhere to be found? They have no representatives to watch their work and make sure that their work is being done in conformity with what the GC wants?
Well,
Is that what you're saying?
Not necessarily, Your Honor. I think that's an issue that needs to be fleshed out. Again, this is so infantile here, but there's also the issue of comparative negligence here. So even if they were partially at fault.
When you're speaking of comparative negligence, you're talking about the
The
plaintiff,
plaintiff.
who's riding the scooter on the
I'm
sidewalk?
talking about the subcontractor.
The
You're saying
subcontractor.
that
Comparative negligence as to the subcontractor?
well, yeah.
Counsel,
where-
aren't there Google photos showing this crack prior to this accident?
So they are inadmissible.
Did
We
you
don't
argue
know
that
where.
below?
I'm sorry.
Did you argue that below?
Did you argue an admissibility below?
Yes. Yes, I did, Your Honor.
Can you tell us where on the record that is? I don't want you to finish what you have to say. You could-
Oh, you mean in the motion court? No, we argued that on appeal in our appellant's.
So to the motion
respondent's-
court, you didn't argue that it was inadmissible, correct?
That the photos were inadmissible, nor did we have to, because that's a question of law that if
That's
brought
not
up,
a question of law.
admissibility of the photographs wouldn't be in a, I mean,
The admissibility of the photograph? You're saying that's, why isn't it in it, why is it inadmissible?
the photographs are inadmissible because they did not provide the required CPLR 4532B notice of intent to use them. And they also did not provide the web address. They didn't provide.
And you didn't
don't
argue
raise
this in
it.
the motion court, but you think you can argue this now?
Yes, because it's a question of law on the face of the record that if it was brought before the motion court could not have been avoided. But before that, I just want to mention, because I know I'm,
You're way out of time, but go ahead, I'll give you another 30
if
seconds.
I may, just on the prematurity issue, we covered, the fact that the subcontractor needs to be questioned to find out what work they did and what they might have done to cause the defect that injured the plaintiff. But the real crux of the matter is here, we did not have the
So
opportunity to depose the plaintiff.
Your entire argument is based on speculation that they have information to give.
That the-
Because you have to come forth with information, say, there was nothing wrong with that sidewalk. There were no cracks, the joints were fine when we hired them. Then, if you had come forward with that kind of a statement, an affidavit from the person who took care of your building, or who came and inspected the site prior to beginning your GC work, maybe. But I have nothing but speculation. But I've heard your argument, and we'll look at the briefs.
Thank you,
You're
Your Honor.
next. Thank you. You may proceed.
Good afternoon, Your Honors. Guy DeRosier for the respondent, J.P. Morgan Chase. I'll be very brief, as I said before. I don't want to repeat anything that's been said before, but I do think there is some issue here that goes beyond just speculation. And in fact, I don't think it's speculation at all. If you look at the notice of claim, the notice of claim specifically referred to, and I'm quoting, a missing pedestrian/sidewalk ramp. We don't know what that means because that was never explored at the 50H hearing. But if you look at the photos that are attached to the notice of claim, at least two of those photos on page 353 and 354 show that where this joint is, the plaintiff was on a scooter. He's 6'2", 205 pounds. Presumably, if I were in his position, I'd be looking for a pedestrian ramp to get when I get to the corner. There's no pedestrian ramp in the area.
I'm on a scooter, I stay on the street. Sidewalks are for pedestrians.
Correct.
But that's just me.
Right. This was a kick scooter. It wasn't.
Let me just ask you a question,
wasn't a
because you're
motorized.
going down this road of no pedestrian ramp. Was that something that Arsenal was supposed to do in their contract?
Well, the thing that's interesting is that if you look at these photos that are attached to the notice of claim, the foot of the scaffold is where the pedestrian ramp ought to be, or at least you see just sort of the beginning of the pedestrian ramp. So if this person was coming looking for the pedestrian ramp, it would have been to his right, which is where the scaffold footing is. Since nobody's been.
So there was no pedestrian ramp, or there was a pedestrian ramp and the scaffolding blocked it?
It seems like it wasn't a standard pedestrian ramp, it was a piece of asphalt. It looks, I'm just, again, going from.
Based on the photograph I see on page 425, there is a pedestrian ramp on the Park Avenue side, and the pole that is next to the ramp is the traffic light, not the scaffold.
Well, if you look at the photograph on pages 353 and 354,
I don't have those in front of me, but I will mark it down and take a look.
those are the ones that were actually attached to the notice of claim.
Okay, but it's the same location. So
the same
whether it's
location.
353 or the photographs I'm looking at 425, they would presumably show the same thing from different angles. And again, what I see in the photograph at 425, the only pole that interferes with the ramp, the sidewalk ramp, is a street light, not the scaffold. But we will take a look at the page you cited, sir. Thank you so much.
Thank you, Your Honor.
You have 1 minute.
I think I'll just, if the court has any questions.
We'll rest on your briefs. Thank you so much. And I'm sure your colleagues behind you thank you too.
You're welcome.
Salama versus Rabowska. Did I say that right? I hope I haven't mangled your name too badly.
Thank you so much.
Okay.
Good afternoon, Your Justices. Thank you so much for the time and opportunity. I'm
Can you just bring
defendant.
the microphone down just a little bit?
I'm defendant appellant. I was representing myself in the lower court as well.
Sorry, who do you represent?
I'm defendant appellant, and I represent myself in the lower case during the litigation as well. I brought for the appeal 2 issues. One issue is the storage. The storage amount is calculated incorrectly. There's evidence that there's no summons filed in April. It's only in August. The award is from February 2015 till August 2016, which is 18 months. The lower amount of invoices presented is 268. So the calculation of this, it does not come to 1,372. It's 5,000 something. So this award is incorrect.
Okay.
Based on the second issue, which is the judgment itself, appellant brought to the court that the court didn't apply the law of Egypt where both marriage and the registration took place. Court also changed the rules how the party shared finances based on the Egyptian law. We do not share finances. Every party have separate finances, and it's mandatory from law.
So that is the way that it functions within Egypt, that
Yes.
a husband and wife are required to maintain separate finances?
No, Your Honor. The parties are required to choose the system. If the parties do not choose the system, which is in our case, then the finances stay separately.
Okay.
The Bronx court actually was trying to apply in the judgment that parties will share the finances, which is extremely harmful to defendant. I entered to marriage in 2012, and the judge in 2013 is now trying to announce that I will have to share something, which I never agreed to. So I believe that the court doesn't have any rights to change already signed contracts condition and should to be applying the condition which party agreed to. Based on this financial issue, the court did not resolve the apartment number 4 and unused found in 47,000. What court, despite of the Egyptian regular law, I believe make incorrectly, the court divide the property. Unit number 5, it's only extension of the apartment number 4 and do not have any separate documents. That was
You can't sell that unit separately.
no.
So 4 is really 4 and 5.
4 is extension of 5.
It's a duplex.
It's kind of a duplex. It's villa, which the upper apartment have a roof. The unit is built on the roof. So the ground of unit number 5, it's the roof, which belongs to number 4. So the defendant believed that the court should to address this issue absolutely correctly. as one unit and not as
Are
extensive
the units,
especially.
are the units treated as one for purposes, for example, of an assessment, like a tax assessment?
No, because the units,
So in Egypt, how does the government of Egypt look at these two, 4 and 5? Do they see, let me finish. Is 4 and 5, according to Egypt law, one apartment? Or is it two apartments?
should I address it? The unit number 4 was a purchase, that's the sales contract, and it was in 2012. The extension of that, which is called Unit 5, it's in 2014, 2015.
To get into the upper one, do you just walk up the stairs
You need to use the stairs of apartment number 4.
from
To
inside?
go through number 4 to get to number 5?
You have to use the stairs of number 4, enter the roof, which is belonging to number 4, and then you can entrance to unit number 5.
If they were to be sold, would they have to be sold as a complete unit, or could you sell 4 and or 5 separately?
Well, if we were considering selling the unit number 5, the unit number 5 should to be, first of all, having any documents. The only documents which was presented is permit to build, which was not even obtained for the plaintiff who is in the sales contract number 4.
Ms. Grabowska, in order to gain access to unit number 5, do you have to enter inside unit number 4?
Not inside the unit, you need to use the stairs which are on the
side.
But the stairs are not common stairs for the villa. They are the stairs of unit number 4, which connects number 4 with the roof.
But you don't have to actually go inside unit number 4, but you can go up the stairs. Are those stairs like on the side of unit number 4?
Yes, they are on the side on the villa.
And then you continue up those very same stairs to reach unit number 5.
Yes. But these stairs were never divided. That, for example, if we would like to say, okay, I want to say unit number 5, this should to be any document extracting the property number 5 from number 4, and that should to address how that entrance will happen.
I understand.
Yes.
But what I wanted to know was whether or not someone living in unit number 4 does not have access to unit number 5 unless they come out and go up the stairs.
Someone who lives in apartment number 5 will have to use the roof and the stairs of apartment number 4. So he cannot exit or he cannot enter. Now, the owner of apartment number 4 may say, well, I never agree for somebody to use my roof to enter. So this apartment is not separatable because then there will be conflict of the entrance.
You have to sell it as a whole.
Does the unit number 5, is that a fully functional, habitable unit? So does it have a bathroom? Does it have a kitchen? Does it have any of that?
No, this unit actually is under construction. It's completely unfinished. The only document relates to number 5. It's actually permit to build, which
And
was
on that permit to build, it describes it as a room. It doesn't describe it as an apartment.
yes, it's describing as a service room.
A service room?
Service room. So
Like for a maid?
yes. And also, I would like to bring to the attention that the size of the unit, and then we have another issue, which is the motion, which was never addressed by the court, and court closed the case by signing the judgment. Plaintiff was trying already. We didn't even left the court. I have no access to the property. I have no chance to even secure my belongings. He stole everything, despite the previous order. He needs to return whatever was stolen previously. He attacked my mom, U.S. citizen, a woman, and his mother-in-law. So that should to explain you how far he can go to disobey the court orders.
Thank you so much.
Thank you so much.
Thank you very much. Charles Condominiums versus Victor RPM.
Good afternoon. My name is Keith Stevens. I represent the defendant appellate, Victor RPM. May it please the court. There's been a false narrative going on throughout this whole litigation. Victor RPM is a development manager, not a sponsor. They're not a GC. They're not a construction manager. They're not a contractor.
So, counsel, looking at the development agreement at section 2, it says that Victor shall perform or cause to be performed all work necessary to construct and build. And later it says in the BLA documents that are part of the construction documents at 10.1B, work shall be completed in a good and workmanlike manner with materials of high quality in accordance with approved plans and free of defects. Isn't that language that's normally used in the contract of a general contractor or a subcontractor?
It sometimes could be, and I would be the first to admit that the development agreement is not artfully worded. However, when you look at the four corners of the agreement, it creates ambiguities which basically require to look at parole evidence.
What ambiguity?
Okay, Section 4. Section 4 of the development agreement specifically states that Charles, who is the owner, retained Triton, the construction manager, and Triton and its subcontractors were responsible for performing the project work in accordance with the plans and specifications. Sections 2 and 3B.
Why is that odd?
Why is
a
that?
GC normally does the work. So why is that odd?
Because the GC is responsible for the work. Here they're trying to hold Victor responsible for the quality of the work.
Are you saying that there's only that a builder can only have one person in charge of construction? I've certainly seen construction manager plus a GC plus a safety site, and all of them are responsible.
Absolutely.
So why does your client get a freebie, as you would like to give him?
When you look at the contract as a whole, it's clear that Victor was retained for financing. They were retained in order to provide.
Counsel, under section 5A, it says Victor shall promptly cause the commencement and diligent continuance of the construction of the project work by the contractor under the construction contract until completion. Isn't the problem basically section 1 of the development agreement where it states that Victor is solely responsible to ensure completion?
Ensuring completion is the same thing as coordination. It's for.
In your eyes?
I'm sorry?
In your eyes?
No. When you look at the development agreement as a whole, where it says that Charles is to retain the construction manager who is responsible for performing the work in accordance with the plans and specs.
And he's responsible for making sure they get all the work done.
Who is?
Your client.
Victor.
And by the way, you don't get to ask us questions. That's not how this works, okay?
I apologize.
All right, good.
Okay. Not for getting it properly done. There's nothing in there that says that, where a development manager, when you look at all the clauses, when you look at the financials, when you look at section 4, when you look at.
What about section 2, counsel? Development manager shall perform all work necessary to build out the project at the owner's expense. Project work shall comply with all requirements, including construction loan documents. Doesn't development manager shall perform all work necessary mean perform?
I can't argue that. What I'm saying is there are ambiguities when you look at the sections as a whole, when you look at sections.
But you would agree that paragraph 2 has no ambiguity, wouldn't you?
Paragraph 2, when it says at the owner's sole expense, if you were a GC or CM.
I'm not talking about the part not the part about who's going to pay for it, the part about who's going to do what, which is perform all work necessary.
If Victor, I understand what you're saying, and it does say that. Yes, so I'm not ignoring the question, okay? What I am saying, though, is when you have these competing clauses saying who is actually responsible for the construction, when you look at the document as a whole saying that Victor's compensation was premised upon the gross sale proceeds as opposed to, say, a contractor where it's based upon like a flat fee or time and materials or something like that.
Parties are permitted to chart their own contractual course, and your client charted his contractual course. He didn't have to agree to be responsible for making sure development was done. He could have said, no, I'm going to get you the financing, and that's it, one and done, and your GC is responsible for that. He agreed to this language. Why should we not bind him?
Because there are ambiguities in there that open us up for discovery. You're basically, a development manager who has about 5 employees is being held to the same standard as a construction manager or GC.
Because he contracted to do so. But I'll hear you on rebuttal.
Thank you, Your Honors. Jeremy Cohen of Braun Hagee and Borden for the Charles. There's nothing ambiguous about Victor's obligations in the development agreement. The words cause, perform, supervise, be solely responsible for. Those are
Now,
words.
your adversary is right that typically somebody who procures the deal and gets the financing usually isn't on the hook for making sure that the development takes place. So is your position, as I've been questioning your colleague here, that the problem is he signed up for this?
He did.
The contract is clear.
Absolutely signed up for it, and that wasn't the words that Victor used in its brief to describe its obligations under this agreement. Words like limited, administrative, facilitate, coordinate. Those words don't appear in the development agreement. Cause, perform, supervise, be solely responsible. And what is it that they have to cause, perform, supervise, and be solely responsible for? All of the project work. So to Victor's argument rests on the assertion that when the development agreement says all, it really means none.
So, counsel, if you would compare paragraph 2, which says that the development manager shall perform all work necessary to build out the project, with paragraph 5B, which says that the development manager shall be solely responsible for the supervision of all the project work. Is that an ambiguity, or is that a definition, or how would you characterize that?
Fully consistent with Victor's broad obligation.
How so?
To make sure all the construction was done correctly. They have to cause the construction, and if you look at 5A, right, it says Victor agrees to cause Triton to construct the project in accordance with the construction loan document. So that's defining Victor's obligation. Yeah, they're not the ones with the hammer and nails, but they're supervising the people with the hammer and nails. They're causing the work to be done by the people with the hammer and nails, and they've got to make sure that it's done right, which means in a good and workmanlike manner, free of defects.
And does their numerical size make a difference? Your adversary says that they weren't many people as opposed to the people actually doing the construction. I've never heard that argument before, but it's interesting.
Let me, if I might, this is how Victor describes itself. On its own website, it's on the docket below. It's not in the record, but it's NICEF number 29 on the docket below, which you can take judicial notice of. Founded in 1994, Victor Group is one of New York's most dynamic development and construction companies. Its projects are located in New York City and the tri-state area, and they range from multi-unit residential communities and corporate campuses to exclusive residential condominiums whose signatures include superb design and enduring workmanship. The company's management team combines decades of international construction experience, and it carefully oversees every aspect of the development process from land acquisition through design, marketing, and construction. That's who they are.
Every aspect.
Every aspect.
Thank you.
Thank you, Your Honors.
You have 2 minutes.
Thank you. Victor didn't retain Triton or the subcontractors. Victor is not a sponsor, or so Victor is being held responsible here if the lower court order were to be sustained for the defective work by others. There is no question that Charles alone hired the contractors and hired the design professionals.
Counsel, we really do have to read a contract according to its 4 corners. You're asking us to go beyond the contract, aren't you? I mean, we didn't negotiate this contract.
Of course.
And he's being, I would imagine not.
Right.
We would imagine that, that Victor is being paid accordingly for assuming all of these responsibilities.
They're being paid for based on a sales for the development management role. In the original papers, in the summary judgment motion papers, Charles annexed the contract, Triton's contract. So that's already out there. That's not, necessarily parole evidence. It's already part of the papers. It shows crystal clear, that Triton was solely responsible, and its subcontractors were solely responsible for this. To hold Victor responsible with zero discovery and not give it a chance to explain the differences between development manager, construction manager, sponsor, and GC isn't right. And if I could say one more thing, because we had questions, a different argument that I haven't had a chance to make.
Okay, go ahead.
Okay, thank you. So in the court's original order, the court raised sua sponte the construction loan documents. The court wanted to know what was the definition of complete, and did Victor meet that? They did. I showed that in the brief. We completed the project in accordance with the construction loan documents. The construction loan documents specifically say all work has to be done in accordance with the plans.
Counsel, it's not possible because the Rand reports and the Cummings Corporation photos show that there was improper pipe installation and bent, chilled water risers.
That occurred over a year after Victor was done with its day-to-day services. Who knows what caused that?
Oh,
There's been
come
no
on.
discovery.
Pipes don't bend in a year because they were in the walls and they just fall apart. Come on. Thank you. Nice try. I credit you for arguing to the tooth for your client. I appreciate that very much, sir. People versus Manuel Vega.
Le tocó a mano ese caso.
You may proceed.
Good morning, everyone. My name is
Good
Justin
afternoon.
Bones.
Good afternoon.
We've been here a while.
Actually,
It's okay.
been up
It's
all
almost
night.
Friday. Go ahead.
It is, it is. Good afternoon. May it please the court, Justin Bones
afternoon.
on behalf of Manuel Vega. I was really considering how long I actually really needed to argue here, because this is a narrow issue. It really is. And this, I believe this court does know this case very well, because it was in front of this court in 2004. And without question, I believe that DNA testing there is a reasonable probability that a different result would come about from DNA testing here. Now,
Isn't that wishful thinking, counsel?
Your Honor,
Isn't
you're a
that
little-
wishful thinking in light of all the circumstantial evidence and the DNA testing that already took place?
well, I didn't hear the last part.
She said, isn't it wishful thinking?
No, I don't think it is wishful thinking. And I think that is a good question, though. And the reason why it's not wishful thinking is every time a court grants DNA testing, it's about discovery. We don't know if the DNA is going to be on the item that we're asking to be tested. And I want to correct the lower court.
Would that not just
Excuse me,
show,
I'm sorry.
sorry, that there was someone else present in the apartment at some time prior to the murder, right?
Right.
But we know that from the
Yes.
testimony. We
Right.
know that there were other people there. That's what people testified to.
Yeah, the brother lived there, the cousin lived there, we know that.
Right, that's correct.
So DNA testing would not even, let's say you're right, that DNA testing would show the profile of another contributor. Even that, though, doesn't tell us when that contribution was left in the space, so that it could be at any time. It doesn't point to a lack of guilt in any way.
I respectfully disagree.
Okay.
I'm not asking for like a hair that's found in the corner of a room that could have been left by somebody. I'm asking to test the pillow that was used to suffocate Ms. Vega. And that pillow was found in the marital bedroom. It wasn't found in the other two bedrooms. It was found in the marital bedroom. I'm asking to test and let me be clear here, because Judge Clancy, at the end of her decision, says that we're only requesting male-specific DNA. No, that's not what we're asking for. We're asking to do touch type and trace DNA just like gun cases are done every day in this city. So we're asking to test the pillowcase that was used to suffocate Ms. Vega. We're asking to test the gown that she was wearing, and even the ME states that it looks like the person that committed this murder used a pillowcase to suffocate Ms. Vega and actually was on top of her. We're not asking to test things that we're not involved with. We're not shooting in the dark here.
Wasn't this tested already?
That's great. That
No,
wanna
but
ask a-
I'm
I don't wanna
going
ask a question because
I'm
I heard
going
don't ask a
somewhere because under the statute, is there a, are you entitled to a second test?
How can you test something that you didn't have the ability to test in the first place? Back then, there was no ability to test, touch, type, and trace DNA.
So that's a new method.
That's a new method.
a new method.
So
Correct.
every time there's a new method, the courts have to allow all evidence that was utilized in criminal prosecutions and then allow all of that evidence or part of that evidence to be retested on the hope and the prayer we might find something? Don't we need something more than that?
Not all cases, just this one.
So, Counsel,
Ah,
how does
good
it-
comeback.
Good try.
But tell me why this one stands apart. Because I have to use a decision here. I have to think about its prospective use going forward. So explain to me why this one is different and why this one should create a new little niche. Why?
You guys said it best. This is a whodunit, a completely circumstantial case. And Powell even talks about that, where even an unknown profile could give you a third-party
So,
culpability.
Counsel, how does this differ from People versus Concepcion, a 2013 case where the court found that additional testing would at most show that someone other than the defendant or the victim was in the apartment? A highly speculative theory is not the basis for DNA testing. I mean, we do, as my colleague pointed out, we know, my colleagues, plural, pointed out, we know that two other people were residing in the apartment. We already know that. So what's the grounds for additional testing?
Again, it goes back to what we're asking to be tested. And there were 3 additional fingernails, like in Bush. Bush required retesting on nails that even augmented in Bush the third-party culpability argument. Here, there is a question about identity, and the testing that we want to do is about specific items that were involved with the murder. And interestingly, like when you look at Brady, and I know I'm kind of, this is a little different argument. Brady talks about evidence that could have been used to investigate further. This is a discovery motion. Ultimately, I get the evidence and I make the argument, okay? And ultimately, it's what a single-minded defense counsel would do with this evidence. And to say,
But counsel, the standard really here is that there be some probability that the verdict would have been more favorable to the defendant if the retesting was ordered. The retesting would show, yes, a third person, but what we're lacking here from all of the other evidence would be any other person's motive.
Yeah.
well, potentially, and I don't want to say potentially because I don't want to open the door that wide, but again, this goes back to there were 3 bedrooms in this house, okay? The back bedroom where she was found and his cousin lived in. There's another bedroom that was unoccupied, and then there was the marital room. The pillow itself was only found in the marital bedroom.
Also, but isn't there a history of domestic violence here?
There is. There's also a refuted history of domestic violence.
Right, he said everything was fine, but there was testimony, at least from one neighbor, that the wife came to her in a bloody mess. Twice, in different years.
And stayed there several days until he convinced her to go back.
Yeah, and her employer saw her also bruised, that she couldn't go to work that day. You know, she was sent home. So I don't understand when you're saying there's a disputed domestic violence history here. He did say that everything was good with his wife.
He did.
Yeah.
He did.
All right, you'll have time on rebuttal.
Absolutely. Thank you.
Good afternoon, Your Honors. May it please the Court, 88 Josh Weiss for the Office of the Bronx District Attorney. Your Honors, the motion court was correct to deny defendant's sweeping request to compel OCME to conduct additional DNA testing on the crime scene evidence. The motion was an improper attempt. The motion was an improper attempt to obtain retesting of.
Well, Counselor, is it really retesting when the test that he's asking for did not exist at that time? It's testing in a different form, right, with new technology.
That is absolutely correct, Your Honor. But I would note that this court this court held in People v. Espino that the statute simply does not permit retesting. It does not allow defendants, convicted defendants, to avail themselves of modern or more sensitive.
The statute doesn't provide for retesting, is what Espino said.
I'm sorry, Your Honor.
The statute doesn't provide for retesting, not that the statute doesn't allow retesting.
It doesn't prohibit it, it just doesn't
No, you're right.
require it.
You're right, Your Honor.
So why shouldn't,
by the text of it,
why
it doesn't
shouldn't we allow for this retesting, seeing as this method was not available at that time? And as we know, the more time goes by, the better the testing gets. So why not allow for the testing of this under this new method?
Because I think Judge Clancy got it right in concluding that there wasn't a reasonable probability of a different verdict. Of course, given the number of people who had access to the apartment, it is conceivable that DNA could be found on any one of the crime, any piece of the crime scene evidence if it were retested.
And there was
although I mean, to the extent that your adversary says, in particular, we want the pillowcase that we know is alleged to have been used to suffocate this victim. I have a lot of visitors come to my house. People don't touch my pillow. So the fact that there are other people in the house should not mean that there are fingerprints on my pillowcase unless you were supposed to be in my bedroom, right? So why not test the pillowcase?
Sure, Your Honor. Well, I would just note that it wasn't that people were merely present. They were people who were actually staying in the house, residing in the guest rooms for several nights a week.
Right, in the guest rooms, not in the marital bedrooms. And then we had a witness who testified that he was in and out that night when the murder allegedly happened, the same night.
Right,
Murder
correct,
happened, not
correct, Your Honor. The defendant's cousin. My answer, Your Honor, is that even if somebody else's DNA were found, it doesn't negate the extensive evidence of domestic violence that defendant exhibited toward the victim in the years leading up to it. It doesn't negate his statements to the police in which he admitted that he was at the apartment at the time that the murder occurred, according to the examiner.
And let's talk about that for a minute, because
Sure.
it seems to me that one of the strongest pieces of evidence, or the lack of evidence as a result of the statement, was the statement by the defendant that he had had sex with his wife, and yet when she was examined post-mortem, there was no semen found in her.
That's right, Your Honor. And as this court found on direct appeal, that appeared to be a ruse intended to conceal the strained nature of their marriage, the deteriorating state of it in the years leading up to it. And it really dovetailed with the evidence of domestic violence, that this was an abusive relationship that unfortunately culminated in Miss Vega losing her life at the defendant's hands.
Counsel, where was the body found? In which of the rooms?
So the body was found in a second guest room beneath a futon, wrapped up in 2 comforters. The trial testimony established that at least 2 other individuals, defendant's cousin and defendant's brother, would stay in that room several nights a week.
And according to the defendant himself, he has slept in his bed with the victim that very night.
Yes, that was his version of events.
That was his version of events. And they had sex that very night, correct?
Correct.
And then he left sometime in the early morning hours.
To go to work, right.
To go to work.
Mm-hmm.
And the pillow that they want retested, where was that pillow found?
I believe that pillow was found in the defendant's bedroom.
In the defendant's
In
bed.
the defendant's bedroom.
What was the estimated time of death?
The Emmy estimated between 10 and 11 p.m. There was a possibility that it occurred sometime thereafter, but she said that it was unlikely the further away you got from midnight.
At a time when the defendant said he was sleeping with his wife?
Around that time, between 10 and I think he said he got up at 1 or 1:30 to get ready to go to work.
And the cousin, I believe he was moving out, he testified that he did not see the wife that night.
So the cousin was in and out of the apartment about 3 times that day. He came back at about 7:30. I think he conversed with the victim and the defendant. When he came back later that night, around 11 and 11:30, everything appeared normal. The house was quiet. From his standpoint, it appeared that everybody was asleep.
Including defendant and the victim. They would have been in their bedroom at that time.
Yes. Based on defendant's version of events, they were both asleep.
Thank you.
Thank you, Your Honors. We ask for an affirmance.
Just briefly.
You have 2 minutes. Go ahead.
The Emmy testified that time of death could have been as late as 9 o'clock in the morning, which would have had my client would have been at work. It was pretty well established when he went to work. We roughly left around 2:20, I believe, and then arrived at work at 2:30.
So she was supposed to be meeting a neighbor
At 8.
at 6-something that day so that they could go job hunting.
Right.
And that neighbor called on her that morning and got no answer.
Yes.
And-
My client called well, you're
First,
right.
the neighbor called and got no answer.
Yes, that's
And then your client called the neighbor, and the neighbor said, "Well, I called and I got no answer."
right.
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 And your client called sometime after 9, around 10 o'clock or so.
Yes.
I believe he called 7 the first time, and then I think it was 10. It was 10 o'clock in the morning. Yes, correct. That is correct.
And the just getting back to what the medical examiner testified to, the medical examiner pointed to the condition of her corneas being cloudy, and the doctor said that usually does not occur until 24 hours after death, which is why she thought that the death occurred closer to 10 p.m. than later.
I understand that. And one of the things that I know from doing this for quite a while is that time of death is all over the place. You can have a 12-hour window on time of death, especially when you have somebody that struggles, the heat of the room. I mean, there's all...
But all of this was brought out at trial. Even those arguments that time of death might have been different, and the retesting that you're specifically looking for doesn't necessarily mean that there couldn't have been a conviction or that there was more likely that there would have been an acquittal, because we have all this other evidence that the jury heard it and they came up with a conviction.
I didn't hear the last part, Your Honor. What was it?
All the other evidence that's there, that you're talking about, that we discussed, the time of phone call, the time of death, maybe the difference that there wasn't the time of death, all of that was presented to the jury. How would retesting of the pillowcase change all of that other evidence that's already there, that would make it seem that there would be more likely that there would have been an acquittal? Because again, of all this other evidence. Did I not ask my question correctly?
Yeah.
Yes, you
Oh.
did.
I was getting
think
ready
he
to...
just-
I was going to answer.
He's formulating his
You're
answer.
pondering. Go ahead.
I wasn't
Formulating
even-
his
I-
answer.
I know where you're going. That's a great question.
We know.
Third time.
But so if the cousin's DNA is found on that pillowcase, that doesn't change everything.
It doesn't tell us when the cousin's DNA got on the pillowcase. And
What if the cousin's watching TV with his cousin on the pillow? We don't know.
The pillow is never the pillow is in the marital bedroom. There's not a single shred of evidence that somebody goes in the marital bedroom. There's not a single shred of evidence
except your client.
except for my client, right?
So maybe that's exactly what the jury thought.
And you know what? I'm going to have to live with that with DNA testing. It wouldn't be the first time I would be wrong.
Right.
But I would be willing to test that. Are we going to let a man sit in jail for something that he didn't do? Or are we going to just test it? Doesn't justice, this is where.
So then when we get back to that point, your position is that we should now implement this law, that when new forms of testing come out,
Right.
this should be our case law, when new forms of testing come out, people should be entitled to retest, even if there's no other reason other than new forms of DNA testing now retest. And I think that would be something that maybe some people can argue before the legislature, because they can write that into the law, into the statute. But that's not what we have right now.
I will say that's where I this is different than, I don't want wholesale here. This is different. We have evidence of another party that's.
No, we don't. We don't. That is your argument.
That is my argument.
That's your argument. I don't believe that there is evidence of another party. But we have your briefs, and we will consider them thoroughly.
Thank you.
You have a good day. All right. Kawoa, I know I messed that up, so forgive me, versus ANA Aircraft. Can someone tell me how to pronounce that properly?
Good afternoon, Your Honor. Kiowa.
Kiowa. Thank you. Okay. I definitely got that very wrong. All right.
Good afternoon, Your Honor. Florence Rostami from Florence Rostami Law for Appellant Kiowa Seni. May it please the court, we are here on several appeals that are before the court. Kiowa has asked this court to review the trial court's decision that dismissed Kiowa's action based on lack of personal jurisdiction and sanctioned Kiowa for.
Well, you had your full day in court in Japan, all the way through their courts. The appellate court affirmed the decisions below, and then you come to this country and you've refiled the exact same litigation. Am I missing something?
And the judge here tells you that you should withdraw it several times.
Well, once. Yes, yeah, I agree, Your Honor. The court did, and Kiowa decided not to.
Apparently. And so you are here.
So we are here. Now, what did the Japanese court decide? They decided, and I'm almost quoting their decision, that it is impossible to find the cancellation of ANA of its contracts with Kiowa to be in violation of the principle of faith and trust, offense of public order and morals, and abuse of rights, and the application of the FAA rules cannot be a direct issue with respect to the dress covers, and there is no choice but to deem the said allegations of Kiowa as lacking premise and irrational. The Japanese courts decided that because ANA was flying under Japanese flag, it was only subject to airworthiness standards of Japan. But that was not the case, the issue before them. The issue before them was whether ANA had misrepresented its authority to certify its manufacturing process were in compliance with the FAA standards, and whether they had, in fact,
they basically held that this Japanese company did not have to adhere to US FAA standards, right?
That's true.
Okay. So you got a decision, you didn't like the decision, so you decide to bring it again here. Why is that not res judicata? Why are you not collaterally estopped?
Because, as I said, the Japanese decision didn't find or did not sidestep the decision that ANA had misrepresented, and it was a misrepresentation.
But that's their ruling.
Even if it wasn't the FAA rules.
Counsel, but that's their ruling.
Doesn't matter.
That's their ruling. And we cannot review their ruling.
Counsel, plaintiff's claims relate to the termination of an agreement that was negotiated, signed, and performed in Japan by Japan companies, and it involves an alleged misrepresentation made by a Japanese company in Japan and an injury suffered by the plaintiff in Japan, where it's located. And the Japan court said, you got nothing here. So what can we do?
Well,
What's our jurisdiction?
I believe that's not the case, or Kyowa believes that's not the case. They,
So because their planes flew into either JFK or LaGuardia, that gives you jurisdiction here?
yes,
No. Because then every state in our union would have jurisdiction. That cannot be the case.
ANA specifically and intentionally decided to involve US law and specifically and intentionally retained Kyowa to manufacture seat covers for its flights to the United States.
So, counsel, to the extent that the party injured, the passenger or crew member or whoever it was who was injured was a Japanese national and there's no U.S. national involved, are you perhaps premature as far as what's going to happen in the United States in case somebody gets hurt and sues your client? Or do you think that everything is resolved because the Japanese courts said, you know, there's no problem here, pursuant to Japanese law?
That is a very good question, Your Honor, and I will, the response is that if a passenger is injured in the United States, they will be able to sue Kyowa for
Violation of FAA standards.
That's right. So it is not going to end just because Japanese court has decided that.
But that can't be the basis of our decision here about what might happen in a litigation that might occur some other point, right? That cannot be the basis for a decision here.
But Your Honor, the fact that Japanese court said, I do not have the power to decide the issue.
No, they said that FAA rules don't apply to Japanese manufacturers, and therefore your lawsuit has no basis. That's what they said. But you'll have time on rebuttal.
Thank you.
Good afternoon. May it please the court. Jason Rubenstein for the ANA respondents. I want to respond very briefly to a couple of things my adversary said. It's not just that the Japanese courts determined that FAA rules were inapplicable to a Japanese flag carrier. The FAA determined that FAA rules were not applicable to a Japanese flag carrier. There are multiple instances in the record where the FAA said, this is a Japanese issue. And the Japanese regulators looked at Kyowa's complaints and they concluded there was no safety issue with these aircraft or with the seat covers. The Japanese regulators' remedy for the improper use of the tag at issue was to erase the tag with a Sharpie, not to take the seat covers out of circulation. By the way, they've been out of circulation, we think, for years. Seat covers don't last 20 years on an airplane. My adversary mentioned the possibility that someone, supposing the seat covers are still in use, might be injured by them. I mean, if that's the New York connection here, it's completely speculative. Hasn't happened.
And if that happens, that's on ANA will have to deal with that then.
ANA has never said that it is immune from jurisdiction in New York. It has never said that it can't be sued in New York. But there is no suit-related conduct in New York. There's no tort in New York. There's no injury in New York. So on that basis, Supreme Court, we think, was entirely correct in dismissing the case on jurisdictional
So you're
grounds.
saying we don't have to look at the future and rule now as to what might happen if a U.S. national or anybody flying into U.S. airspace was injured? Am I right?
It's, if the court has a crystal ball, I still don't think it should be consulting it, because it's an injury that hasn't happened and we submit won't happen. And I'd also note that, as Justice Scarpula found, there were 4 other bases for dismissal here that she deemed equally meritorious. The court has mentioned one of them already, which is that this was all litigated in Japan. There was a trial in Japan. Kyowa lost at every level of the Japanese court system. The new evidence that it cites as its basis for suing here, it presented that to the court in Japan in 2016. And the Japanese court said, guess what? We're not giving you a retrial. It was only after that that Kyowa showed up in the courts of New York. So Justice Scarpula focused her decision on jurisdiction and res judicata, but the claims here are also transparently time-barred. As the court knows, under CPLR 202, the borrowing statute, claims that arise in Japan need to be timely both in Japan and in New York.
I just want to frame the FAA letter, which was from 2015. It was narrowly written, wasn't it? It referred to the fact that there was no approval for the seat covers, that a certificate hadn't been issued, a TSOA for a C-127A. But it also said it didn't have oversight responsibility for either Kyowa or ANA, and the matter was referred to the Japan Civil Aviation Bureau. That's within the context of the injury concerning a Japanese national, am I right?
That's correct. Go ahead, I'm sorry, Your Honor.
So that ostensibly, if there was a different type of injury here, or rather an injury here related to the US or to New York or whatever, it could be an entirely different result.
In the same way that if someone slipped on a jetway and were injured, it would be a different fact pattern. Everything that we're fighting about, Your Honor, this was a commercial dispute between 2 Japanese companies where all the performance in that commercial relationship took place in Japan over 20 years ago. Nothing that happened as between ANA and Kyowa happened outside Japan. Certainly didn't happen in New York. So to say that there's any relevant jurisdictional contact here, I think would be breaking, it's just not coherent. I was about to mention the statute of limitations. Kyowa's claims are clearly untimely in New York. The New York statute is you have to assert a fraud claim within 6 years or within 2 years of discovery. Our relationship ended in January of 2005. And so under the 6-year statute, claims are time barred by 2011. The alternative is 2 years from discovery. They asserted the same fraud claim against us in June of 2008 in Japan. So the best evidence of knowing about facts from which you can infer a claim is when you assert the claim. So this case was time barred years before it was brought. One last thing I'd be remiss in noting, we haven't talked much about the fee issue or sanctions, but the conduct here was, by Kyowa, was egregious. And I just want to point the court to one episode during the 8-day fee hearing before the referee, which was focused on determining our reasonable legal fees. On day 8 of the fee hearing, after the referee had heard testimony from me, our Japanese co-counsel, and we were subjected to days and days of cross-examination, Kyowa's counsel announced that they were not going to respect the judgment of the New York courts and that we would have to go to Japan to try to collect on a judgment. And I quote, "My guess is you're not going to get $1." Kyowa later tried to pass that comment off as a joke. I would respectfully submit to this court that bogging us down in an 8-day fee hearing, the sole focus of which was to determine our reasonable legal fees pursuant to Justice Scarpula's sanctions order, and telling us at the end of the fee hearing, guess what, you can go to Japan, that tells you everything you need to know about who we've been dealing with in this litigation. Kyowa's claims have been meritless from the start. We warned them, the court below warned them, They proceeded with their claims with eyes wide open. We would ask the court to affirm the dismissal, to affirm the sanctions decision, and to affirm the fee award.
Thank you.
Thank you, Your Honor.
You have 2 minutes.
Your Honor, the last point. In response, in an emotional response to counsel's repeated derogatory remarks, I blurted an off-the-cuff remark. It wasn't Kiowa there. Kiowa was 13 hours away from the US and was not Kiowa. I did that. I was angry and it was not an appropriate remark. I understand that. However, to use that argument to argue the merits of their position is unfounded. But
I think the history of this litigation speaks for itself.
Your Honor.
How many times and how many courts have to tell you you have no basis before you listen?
Your Honor.
This is one of the most frivolous actions I've seen. Okay?
I do not believe that. And I have, I believe that the fact that Kiowa, a small company, decided not to follow fraudulent instructions by a giant company who knew its instructions was illegal under the FAA rules, falsifying certificates, falsifying compliance with the FAA rules is illegal. They didn't have to do that, they did. They did not have to, but they did that. A small company that stands up to...
But counsel, that's not where the frivolity lies. It lies in the fact that you litigated this to the maximum in Japan, they ruled against you, and then you come to the United States here in New York, and you try to do the same. And as counsel alluded, your claim is time barred, there's res judicata, there is no jurisdiction, and the court below says, for these reasons, you should simply withdraw your claim and you continue, and here we are on appeal. That's where the frivolity lies.
I cannot...
I'm going to give you 30 seconds because your time is up.
Cuba decided to litigate even after what Justice Scarpula decided. That's on us. But I still believe that even all of these
Counsel,
cases...
you're the one who filed the appeal here, okay? Thank you.
Okay.
CUCS, Housing Development Fund Corp. versus Clifford Ames. You may proceed, sir.
Good afternoon. Respondent Appellant Clifford Ames, pro se. This is an Article 4 counterclaim proceeding for zoning violations against CUCS, who failed to deny 82 allegations in my counterclaims, failed to plead any affirmative defenses. The New York City The New York City Administrative Code, Section 7-703.
Sir, what are your damages?
Okay.
What are your damages?
I don't need to prove damages for 3 separate reasons. The first reason is paragraph...
So is the answer to your question, you have no damages?
No. I have
So
damages.
then what are your damages? My colleague asked you a question, we'd like an answer. What are your damages?
Damages is that it affects the value of my property.
And how have you established that? Your saying so is not enough. So how have you established that?
I haven't established it, but please let me make my argument.
I'm sorry, you have established or you haven't?
No, I haven't. The New
You
York
have
City
not.
Administrative Code, Section 7-703K, designates a zoning violation as a public nuisance.
But there's no zoning violations, counsel.
No, that's
Isn't that a
Absolutely.
I mean, not counsel, sorry, Mr. Ames.
No, there are zoning violations. The court hasn't addressed the merits of the zoning violations, not once. This department held in the City of New York versus Continental in 2009 that irreparable injury is presumed from the continuing existence of an unremedied public nuisance.
But isn't this remedy, wasn't the issue of the underpinnings remedied
This
already?
has nothing to do with the underpinnings. This is just a frivolous thing that council here brought up. That issue was
So it's
resolved.
just the existence of low-income housing next to your property that's a problem?
No.
So what's the problem?
The problem is that they're in violation of about a dozen zoning violations.
Now, how so? Because they produced plans that were approved by DOB and the city council.
Okay,
And those plans, I imagine, would not have been approved had they been in violation of any zoning resolution or there were any zoning violations. So that's why we're asking the questions, because we want to know.
the courts, the cases are in my brief, but the courts say that when a municipality fails to enforce their zoning regulations, that a person such as me, as an adjoining neighbor, an adjoining property owner, can bring this action.
But has any court declared that there were zoning regulations? Violations?
No, because we haven't gotten that far yet.
Are there open zoning violations right now as we speak?
Yes.
Which ones?
You mean from the city? No. Well, yes, there are. There are density regulations. There are too many units.
Was a certificate of occupancy issued for the building?
Yes, but that doesn't.
A certificate of
doesn't preclude
occupancy,
me from-
excuse me, sir. Certificate of occupancy is issued after there's compliance with the regulations of the city, yes?
That's not what the zoning. That's in my brief. It's in my reply brief. The certificate of compliance, the certificate of occupancy does not state that it complies with the zoning regulations. Okay. I can't speak for how the city, how the building department runs their operation. Okay, but the law is clear. If there are violations, and it's my right to have the court look at them to decide whether they are or not, and they are blatant violations, that is the issue before the court.
So
If they received a building permit that was in violation of the zoning resolution, that's an unlawful permit. The building department has no right to authorize an unlawful building.
Okay, let's hear the other side and you'll have time on rebuttal.
Good afternoon, and may it please the court. Christopher Slowick, Falcon, Rappaport, and Berkman for respondent CUCS.
Has the Department of Buildings issued any zoning violations to this project?
No.
Was there a review of whether there were zoning violations after Mr. Ames complained?
Yes.
And after that review, were there any violations discovered and documented?
No.
Okay, you may proceed.
And I was going to bring those facts to Your Honor's attention.
Sorry for cutting to the chase.
That's okay. No, not at all. Mr. Ames had a full opportunity to relitigate, if he had not before, where he had filed multiple applications for the same relief. He had a full opportunity to litigate this upon remand after this court determined that his counterclaims had not been fully.
There was a full hearing here.
There was a full hearing.
Briefing,
Yes.
correct?
There was discovery, there was voluminous document exchange, there was a full hearing.
Now, am I correct that this new building, which is a 12-story, 117-unit, multiple dwelling for low-income and formerly homeless individuals, This building was erected next to an empty lot owned by?
Respondents, Mr. Ames' property has a building on it that
Okay.
is uninhabited and unused. It lacks utilities. There's currently, it's essentially a disused shack, for lack of a better word.
So in essence, a operational, brand new, 117 unit building next to what you have just described certainly wouldn't devalue his property. If anything, it increases the value of his property.
I would submit so. You're in all candor, it's a beautiful facility, and it's providing much needed. It also provides outpatient.
This sounds like what one of my former colleagues of this court would say, this is a case of NIMBY, not in my backyard.
For lack of a better way of putting it, I
Okay.
would agree.
Counsel, to what extent has your adversary, has Mr. Ames established damages? He says that the Department of Buildings is not enforcing its regulations, but let me ask, are there any outstanding violations for this new construction?
There are not. And with regard to damages, he has explicitly in the record disavowed damages. He has explicitly disavowed. It's in my brief. It's on page.
We saw it.
We saw it.
He has disavowed damages. And the one thing I wanted to just clarify, because the record is the decision below, I think didn't fully make the distinction. There's not a standing issue here. We concede that Mr. Ames had standing in the first instance as a neighbor. That's what the Sunbright case is all about. You can challenge, but that has to be done within the context of an Article 78, whereby the agencies who spent considerable resources to approve this project would also have an opportunity to appear and contest their work. So that did not happen.
Counsel, is there an issue remaining as to the underpinning
No.
of the building?
No,
Did you sidestep, not you, but did your client sidestep the issue by foregoing underpinning?
After Mr. Ames actually threatened to come to this court and seek injunctive relief to prevent the underpinning, and we voluntarily withdrew it. So we never again sought permanent access to his property in the terms of installing a permanent encroachment. It was just a temporary license to install protections and monitoring equipment during the construction. The building was essentially, our building was essentially eventually built without underpinning Mr. Ames's property. So if there's nothing else.
Thank you.
Ronna, this is absolutely not a NIMBY case. First off, this is an action in law. It's not an action in equity, okay? I don't necessarily seek any damages. All I seek is that they abate their zoning violations. And if they do that, then I'm perfectly fine. They don't have to give me a penny.
What does that mean, tear the building down? You said there were too many units. So other than tearing the building down,
they don't
how
have
do
to
you abate
Well,
that?
first off, that's not, they didn't plead that defense. They didn't plead any defenses, okay? So the fact that they didn't plead any affirmative defenses means that the Court of Appeals in Little Joseph versus Babylon said that zoning violations may be enjoined unconditionally because the defendant failed to plead any equitable defenses. They didn't plead any defenses, and this is not an action in equity, it's an action in law. All I'm requesting is that they abate their zoning violations. They don't have to pay me any damages.
What are the zoning violations?
There are numerous violations.
Like
There's
what?
There's too many units. The building height is too high. There's too much.
Tear the
So
building
what
down.
she says is
Tear
what
the
you
building
want.
down.
No, you don't have
Tear
to
the
tear.
building
No, you don't
down.
have to tear the building.
Got
down.
it.
No, you don't.
Right.
They didn't, and they haven't argued that. You shouldn't be arguing their case for them.
I'm not arguing their case for them. I'm asking you questions, sir.
Right, and it's,
I am asking you questions,
That's- yes.
and I am entitled to ask whatever question I want,
yes, Your Honor.
okay? Thank you. We have heard your argument, and we have your brief and the record. Isali versus Guard. You may proceed, sir.
Good afternoon. I'm Alan Lewis for Mr. Isley. I'm going to spend just a couple of minutes first on why Isley's lawsuit against Burke must be reinstated before going on to why Garda is not entitled to fees. So the case against Burke was dismissed under 3211G after it survived a 3211A7 dismissal. 3211G didn't apply to this case when it was filed. So there are 4 reasons why it is improper to insert a new dismissal standard into the middle of a case that didn't apply at its outset. And the first of those reasons is the holding of the Eustache case, a case on which Judge Mendez sat 6 weeks ago. In that case, this court held that there's no application of 3211G, quote, because this action was commenced in 2019. Just like this one. And before Your Honor had reached that holding in Eustache, you also reached it in Kurland, redesignating the 3211G motion as 3211A7 because the case was filed, that case too was filed before the 2020
So,
amendments.
counsel, which came first, the chicken or the egg? Who brought the case back to the court? Was it your client because he was moving to re-argue the dismissal of the case against Ms. Burke? Or was it Ms. Burke who independently, out of the blue, after the dismissal of the case in her favor, brought the case back so that she could get fees retroactively?
With apologies, your question mischaracterizes.
No. Answer my question, please.
The court, in its December 22 decision, affirmed the sufficiency of Isley's lawsuit against Burke, though it dismissed it against Garda.
You're not answering my question, and it's critical because it deals with the procedure, and you know that procedure lies at the crux of all of this. So, to bring this back, who moved first? Was it Ms. Burke who said, oh, my case has been dismissed. Here are the anti-SLAPP amendments. I'm entitled to attorney's fees because the case involved defamation? Or did the case come back because Mr. Isley said, I'm not happy with the dismissal, I'm going to re-argue, I'm going to do a motion to re-argue and get the case back on the calendar? Which came first?
Apologize, I don't understand the question. The court initially dismissed as.
Counsel, let me make this easy for you because it's going to be really simple to just punch this information into our court computer and we will be able to find the answer to this question. So avoiding the question gets you no cigar. We will get the answer to this question. So the issue is real simple. Who moved first? Did your client move first for re-argument or did Ms. Burke move? That's a simple question. This is not rocket science.
Burke moved to dismiss. Court granted the motion. We moved to re-argue it.
Okay, so you moved first to re-argue.
After the case was dismissed.
And did
Burke
you
had
move?
moved-
So you got
Thank
your
you.
answer.
Thank you. And did you move to re-argue after the enactment of the anti-SLAPP amendments?
Yes.
Therefore, does that put you within the realm of a liability for attorney's fees to the extent that you don't show a substantive basis to go
No,
forward?
because we're talking about the sufficiency of an action that was filed before the amendments, and that's the holding of Eustache. We didn't refile a lawsuit. It was filed
But the amendments, the attorney's fees, is not only commencing, but it's also continuing an action.
That is not correct as to 3211G. The or continues.
And what case says that?
It in there.
What case says that it doesn't apply in that instance?
Eustache, VIP, and Kurland.
Council 3211G specifically says, shall be, you know what, I'll find it, go ahead.
So the lawsuit was filed once in 2018.
I understand that. Let me, because
Here it is.
the second department, the VIP case, the Verlander case, those are the second department. You're citing the Eustache case from this department, which may or may not be aligned with the Reeves case that came out of this department. But what is clear is that the statute does say commence or continue, does it not?
3211G doesn't say
No,
that.
70A of the
76A does
civil,
not say
70A of the civil rights law does. It's,
Only, that's the fee provision, but the dismissal provision. So it's long been established law that motions to dismiss are based on the standards in existence when the lawsuit was filed. That's the holding of the Court of Claims in Charbonneau, of this court in Ruffalo, the Court of Appeals in Berkovitz. Both defendants avoided mentioning all of these cases, although they're all emphasized in our brief. In Charbonneau, the Court of Claims held to apply this statute would invalidate an already served pleading, which was legally effective, when filed. Such a new rule should not be applied to invalidate prior legally effective acts. So the question is, was Isola's lawsuit against Burke sufficient when he filed it? The lower court held it was. That's the end of the story. 3211G does not come in through legislative amendments in the middle of the case, as you correctly held in Eustache. And to Your Honor's question about Reeves, in Reeves, the court noted that the plaintiff abandoned any argument in that case that the action was not subject to 3211G as a public petition action. And so it treated it as a public petition action because of that abandonment. But Eustache is a case where the argument wasn't abandoned and you held you just can't interject 3211G. So to inject 76A suffers from the same problems as injecting 3211G. It redefines an entire category of lawsuit. In the middle of a case, it transforms it with all kinds of consequences. And if the Court of Appeals holding in Gottwald that the amendments, plural, to the 2020 legislation do not apply retroactively, it has to mean that the redefinition of a public petition action, the trigger for all of this, doesn't jump into the case. And in Eustache, you also held quite clearly that the redefinition of an action involving public petition doesn't jump into the case. So where does that leave us? We have no 3211G, we have no 76A. Can we have 70A standing all by itself? And I'd like to quote Garda's brief as a part of my answer to why you can't. So
I'm going to give you, you're out of time, but we peppered you with so many questions. I'm going to give you another minute.
Okay. So on page 31 of their brief.
You're welcome.
So throughout their brief, they argue for their fees based on 3211G and 76A, neither of which they can have, because both would be retroactive. And then they admit that the statute is designed as a harmonious whole. That's exactly right. There's no evidence that the legislature intended in cases where you couldn't have 3211G or 76A that you'd have Section 70A. That makes no sense. In any event, even if Isola's complaint against Burke was subject to 3211G, Burke never submitted an affidavit or made any specific arguments about what made the complaint lacking in a substantial basis. 3211G contemplates specific arguments. 3211G2 is a contest of affidavits begun by the movements. Here's how the case is lacking in a substantial basis, and then the other side gets to respond. There was no affidavit. 3211G3, the discovery provision, lets courts give discovery based on specific arguments that were made. None were made here. Through those.
Thank you. You'll have time on rebuttal. Are you with Guard or Burke?
Guard, Your Honor. And good afternoon, Your Honors, and may it please the court. My name is Andrew Butaro, and I'm here on behalf of Respondent Damian Guard. The Supreme Court correctly held that Mr. Guard was entitled to fees and costs under the amended Anti-SLAPP Act, and that decision should be affirmed in full. The Supreme Court reached that decision after considering about 30 different filings addressing the anti-SLAPP issues in this case. About 16 of those filings came from Mr. Isley alone. And in deciding this issue, the Supreme Court applied the Court of Appeals decision in Gottwald to the letter. Now, I'd like to address this issue regarding public petition and participation that you just heard. The main argument here fails because of three different sources of controlling law, some of which Your Honors just referenced. First, we have the statute itself. The statute speaks in terms of actions that are not just commenced, but that are continued. And then we moved to the Court of Appeals decision in Gottwald, which applied that plain language, noted that the statute provided for its application to continued actions, and held insofar as the amendments to the Anti-SLAPP Act are applied to continued actions, there is no retroactive effect. And beyond Gottwald, we have this court's decision in Reeves, which was referenced earlier. And in Reeves, this court built on the holding of Gottwald and likewise held that in that case, the 2020 Act's definition of public petition and participation applied in full. Now, my friend characterized this a moment ago as an abandoned argument, but that's really not what the decision shows. In referencing an abandoned argument on appeal, Reeves was discussing public interest, which is one component of public petition and participation, and perhaps more persuasive evidence that this argument wasn't really abandoned insofar as it pertained to public petition as a whole. Counsel for Mr. Isley represents the appellants in Reeves and filed a motion for re-argument in that case, in which he expressly argued that the arguments regarding the application of the Anti-SLAPP Act were preserved and said intrinsic, I'm quoting, intrinsic in the Reeves decision from this court is a determination that the 2020 Act's definition of public petition and participation applied. So we need to look no further than the re-argument papers that were filed in that court.
How do we, you know, I guess meld or reconcile the Eustace decision with the Reeves case? Because you have to kind of agree that maybe they're kind of at odds with each other.
I agree, and I think you accurately described that earlier, noting some confusion between the two. And so when we look at Eustace, there's a few sentences near the end that are citing both the Reeves and the Second Department decision in VIP. The decision seems to think that the two are harmonious, but there's a difference between the two. VIP and the Second Department took a much different view than this court did in the Reeves decision. And once again, to quote from my friend's re-argument papers in Reeves, he described the two decisions, VIP and Reeves, as, quote, diametrically, end quote, opposed. And so I think that there's some confusion in Eustace. Eustace was citing to the general language regarding retroactivity, but when you actually look at Reeves and you see how it applied the Court of Appeals decision in Gottwald and the plain statutory language, it's clear that it takes a different view. So Eustace could not possibly be seen as overruling this court's opinion in Reeves.
And we normally don't do that.
Exactly, and I'll add one final point on that note, Your Honor.
I have a question for you, counsel, but I want to hear the final point first.
Final point is simply that there is nothing in the Eustace decision that suggests that it was even purporting to overrule Reeves. It seemed to think it was citing Reeves in support.
Okay, so I'm going to ask you, where is the trigger? How do you trigger 3211G? In other words, if a motion is dismissed, is it dispositive that the motion is dismissed under 3211? Or does a case have to be, right, can a motion dismissed under 3211 trigger, sorry, let me start again. Can a case dismissed under 3211 trigger 3211G merely by the fact that a motion to re-argue is filed?
The answer is yes, and I would say that the trigger for the anti-SLAPP remedies can occur a few different ways. One of the easiest ways they can be triggered is by an adjudication pursuant to 3211G, the anti-SLAPP statute. The statute says that on its own. That's not the exclusive way, however, that the requisite...
But here on re-argument, didn't the court reaffirm its dismissal under the 3211A7?
It did, Your Honor.
And so how do we now jump from 3211A7 dismissal to a 3211G application that comes after?
That we affirmed.
And we affirmed the dismissal.
And I think
And I was on Reeves, you know that I authored Reeves.
And you can correct me, and I think in Reeves, they had moved both under 3211A7 and 3211G. The court, however, in making their decision, only addressed the A7 portion. So that's not kind of what we have here.
No?
Well, I would say a few things in response. First, yes, there was an adjudication in our case as to guard pursuant to 3211A7 and 3211G. We start with the July 2022 decision.
The first decision mentioned 3211G?
It did not, Your Honor.
But that's my point, right? So if the case is already dismissed on the 3211A7, they make a motion to re-argue, and the court affirms, sticks with its original decision to dismiss on the 3211A7. How?
And
do
we affirm
then,
it.
how do we then have 3211G capacity to even entertain that statute when it wasn't commenced with it and the dismissal did not cite it?
Your Honor, the answer to that question is that the way this developed is a product of Mr. Isley's decision to seek re-argument. Now, let's imagine.
So what my colleague, what my colleague is said is, in essence, your argument that by moving to re-argue, he essentially reopened the door for the court to consider 3211G.
Exactly.
Because that now constituted a continuation.
Exactly, and I can explain why with a very brief counterfactual.
No, I got it. Thank you.
Okay.
You're out of time.
Thank you, Your Honors.
Burke goes up next.
I know you're excited, but.
Good afternoon,
Your
everyone.
time is coming, don't worry.
Very shortly, in behalf of Respondent Burke, I'm just going to adopt the arguments of my colleague. I don't have anything further to say. I think that the decisions of Judge Dagos are very well reasoned. He spells out the elements and why it should be dismissed.
Let me ask you questions then.
Sure.
So would you characterize 3211G as a defendant's remedy in a slap case?
I guess the answer is yes, because I think the plaintiff has to make a certain burden to show that they have a meritorious case, and here they were unable to do such. I mean, they didn't even provide an affidavit from Mr. Isley. They failed to even, I think, verify any of the pleadings.
To the extent that discovery was sought under 3211G by the plaintiff, does that serve as a trigger to invoke the protection of the statute for the defendants?
I would say absolutely, Your Honor, because clearly they were trying to go at it from that perspective. Clearly they were looking for discovery, and even though they failed to even make a showing pursuant to the statute, but they were aware of it, and that would trigger it. And I agree totally with that position, because clearly they were aware of this. This was their objective. They were looking for the discovery to defeat it.
Good.
Okay.
Thank you.
Thank you. All right, you have 2 minutes.
Couple of things. First, to respond to Garda's arguments. He cites Gottwald as the basis for injecting 3211G and 76A into this case. Gottwald got to the Court of Appeals well past motion to dismiss and summary judgment. 3211G is not mentioned. When the court gets to 76A, it refers to what this court held in Gottwald about 76A.
Do me a favor, get closer to the mic.
What public petition actions not applying in actions where the complaint was filed before November 20, and then it says, we're not going to deal with that. They expressly declined to deal with it. So there's no way that Gottwald supports the intrusion of 3211G.
They chose not to deal with it because they felt they didn't have to. They could resolve the case on another issue.
Yes, the plaintiff was a public figure, but that has nothing to do with this case right here today.
No, because public figure, it's not only that, it's also an issue of public interest, right?
That's right.
These are different questions, the anti-SLAPP statute and whether somebody is a public figure. But the actual malice burden applied to Gottwald because it was a public figure, and that's why the Court of Appeals didn't decide whether 76A came into the case. but they didn't decide. And it's logical that it doesn't because of how radically it would transform a case in every single way. You'd have to relitigate the case from the beginning 2, 3, 4 years into a
Understand you. You're
lawsuit.
saying that these two actions don't involve public interest? Are you?
That's only the question if you're applying the definition of 76A in the 2020 amendments. This case doesn't fit the definition of an action involving public petition under the law when it was filed. So this is the case transformed into a completely different one with consequences at the motion to dismiss, summary judgment, discovery, proof burdens. Does it become a completely new case in the middle? And when the Court of Appeals said not retroactive, they said no. Last point, a motion to re-argue doesn't trigger new statutory standards. The motion to re-argue was simply the motion to re-argue the 3211A7 dismissal as to Burke, which we won. At the time, the court had held there was no 3211G.
Thank you.
Because of Gottwald. Thank you.
Lopez versus NG 645 Madison. You are with?
I'm with Gallo Vitucci for Zerum.
For Zerum,
Zerum.
okay. It's been a long day, sorry.
I will try not to take too much more time.
You may, no,
You
that's-
take all your time.
You take all the time you need. I'm just saying, I couldn't keep track of who was representing who.
Completely
My
understood.
apologies. You may proceed.
Thank you, Your Honor. Good afternoon. Sarah David with Gallo Vitucci Clar for the second third-party defendant, Zerum Electric, in this case. I respectfully submit that when the court denied my client's motion for summary judgment, it overlooked one key undisputed fact, specifically that this electrical bus duct that the plaintiff cut into was never supposed to have been demolished in the first place. It was not part of the overall scope of the project. And this is undisputed testimony from the building, from plaintiff's supervisor.
Yeah, but it was marked. It was marked by someone, and the plaintiff was asked to cut it. So maybe it shouldn't have been, but he was directed to do exactly that.
And you're Zarin?
I'm Zerum Electric.
Zarin was the company that
electrical.
marked it.
No,
No,
Who
they're
marked
the
it?
electric company.
correct. My client had nothing to do with marking it. It was marked either by plaintiff's supervisor at Vanguard, who testified that he was involved with Real Plumbing, the company that was
Real
doing the
Plumbing marked it.
installation of the temporary sprinkler loop. And
The allegation is that you were supposed to shut off the power.
the allegation is that my client was supposed to have shut off the power for the fourth floor. And in fact, assuming that allegation is true, assuming that the purchase order was in effect as of the date of the accident, which my client has disputed, but if we assume for the purposes of this argument that it was in effect and that my client did have that obligation.
Did anyone tell him to do it?
No, and it's undisputed that no one did. However, after the fire started, after it was cut into, and plaintiff's supervisor and the building and everyone and the fire department went into the basement to check the power sources to figure out where the electrical source was coming from, it was not part of the power source that controlled the fourth floor because the switches and the breakers that controlled power on the fourth floor were already off.
But there were two switches, right? There was evidence in the record that there was another switch that apparently some people didn't know about that had not been turned off.
So the switch that had not been turned off controlled this electrical bus. And the bus is essentially a large duct that ran from a separate room in the basement up through the corridor and the ceiling in the corridor near the elevators on the fourth floor, all the way up to the roof and powered the chillers on the roof. It did not power anything on the fourth floor, nor did it derive power from the fourth floor. It ran through an area of the fourth floor that was not being demolished until that morning when the plaintiff's supervisor and Real Plumbing began marking out areas that Real Plumbing needed to access in order to hang its anchors.
Right.
No one ever requested, no one knew that this bus was there. No one requested that Zerum look at it. No one checked that it was whether it was powered. No one asked Zeram to check if it was powered.
Based on the
Zeram had
record, nobody knew what it was.
And Zeram had no involvement in any of that, nor should it have. So respectfully, I submit that the common law contribution and indemnification claims by the owner against my client should be dismissed on summary judgment. My client is not a direct defendant, just to be clear. You were impleaded by the building. The only other claims against my client are contractual claims. They seek contractual indemnity and breach of contract for failure to procure insurance. Even if we assume that the
Who did you contract with directly?
So that's just not disputed entirely. There was a purchase order from Vanguard. It is disputed whether or not that purchase order was submitted to my client before or after the incident. However, even if we assume that the purchase order was submitted to my client before the accident, of which there is no evidence, even if we assume that that's true, the building owner acknowledges that the purchase order does not require my client to indemnify them. There is no indemnity language in that purchase order. So there is no question of fact that should have.
Well, but for that purchase order, your client would have no reason to be there, right?
Correct.
Okay.
So even if we assume that it was, well, there was work being done elsewhere in the building, Your Honor.
I want to ask you a question with a twist. Who was supposed to be in charge of the electrical specs for this renovation?
Well, there's two different aspects of it. The overall renovation began with demolition of a different area of the fourth floor.
But I'm
for which
talking
my
about the,
client-
there's different kinds of plans. There's plans that show to plumbing, plans that show to electric. So who was in charge of the electrical part?
The electrical part of the demolition project was contracted to my client. However, the bus duct and this portion, the removal of portions of the bus duct so that the plumber could install a temporary sprinkler loop, had nothing to do with my client. That was not an electrical.
Should your client have known about the electricity flowing to that bus? What was it you call it?
To the floor. I mean, look, there's demolition, there's work happening on a floor. Your job is to do the electrical work for the job. It would seem to me you'd want to know from the owner, what's in the walls, what's in the ceiling. Show me your prior plans so we can map out where stuff is.
And
that seems pretty basic.
Was there testimony from the owner that it was Zeram's responsibility to notify the building when it was time to cut off electricity?
It was Vanguard's responsibility to file a contractor request form to turn off power.
But I guess Vanguard would be somehow informed by the electrical subcontractor whether or not there was electricity flowing anywhere in the areas that they were working.
If they had notified Zeram that they were opening up the ceiling of an area that was not supposed to have been demolished, and then choosing to demolish components in that ceiling, which were otherwise hidden, this area where the accident occurred is a corridor near the elevators. These elevators were not being demolished. They were not part of the renovation. The corridor where the elevators were was through two doors away from where the renovation project was occurring. So this was entirely separate from the overall demolition project. This was a temporary sprinkler loop being installed by Real Plumbing.
Thank you.
Good afternoon, Your Honors. Lindsay Caldwell from Litchfield Cavo. We represent the Madison Avenue owner defendants. The project at issue required installing this temporary sprinkler system around the fourth floor elevators, and
well, it seems to me that the party best in the position to know where the dangers lie in their building would be the owner.
Yes.
So what did the owner or their representatives provide all of these contractors, knowing that there was going to be plumbing work that had to be done and worked around electrical systems? What was provided so that this could be done safely?
The area that was marked shouldn't have been marked, so the owner wasn't on notice that there would be an issue.
Again, they knew that they had to mark, right? So you're marking a ceiling, which means you can't see what's inside the ceiling. Only a plan for the building that should be in some cabinet somewhere in that building, in the offices of the owner, that should be available when you're doing construction and you're changing things and having people sawing through surfaces they can't see through.
Which is a good argument to keep Real Plumbing in the case, because Real Plumbing was required to...
It's a good argument to keep you in the case and your client in the case because you're an owner and you have a non-delegable duty.
Well, Real Plumbing was supposed to go around and determine what areas it needed to mark in order to install the hangers for the...
But your friend says where the accident occurred wasn't part of the project. Is she? Your adversary just said that. Was it part of the project where the accident
Shouldn't have
occurred?
been. Real Plumbing should never have marked it. Real Plumbing went through with orange paint and marked areas that weren't supposed to be marked in order to install their temporary
So
sprinkler
are you
system.
saying there was no renovation that was supposed to take place at that location?
There was, but at the time, what was going on was just preparing for it and preparing for demo, and before demo could, other work could take place, they needed the temporary sprinkler system around the elevators for fire safety measures.
Who did the owner designate as the GC here, counsel?
Vanguard is
It was
the GC.
Vanguard, right?
Yes.
And wasn't it Vanguard that marked the ceiling?
No, Vanguard hired...
Vanguard walked around with the plumbing company and told them, mark there, mark there, mark there.
Yes,
That's what
and
the
plumbing
record
company
shows.
marked it with the orange paint.
Based on the instruction of Vanguard, correct?
Which is your agent.
The plaintiff testified that Real Plumbing was the one that decided and marked the anchors, and then Vanguard testified that Real Plumbing was responsible for marking out the areas with the spray paint.
So here's the problem. Basically, what everybody is arguing is, it wasn't me, nobody knew anything, and the Vanguard supervisor, Mr. D. Georgialis, said, I didn't know what a bus was, an electrical bus was. The plaintiff didn't know what an electrical bus was. You can't pass the buck here. Someone had to know where the electrical equipment laid, I don't know how to conjugate that, and where the hazards were.
In the record, it on page 70, says that the plaintiff testified that on the date in question, our plumbing walked the fourth floor area with Vanguard's DeGriglio to determine where in the ceiling our plumbing would install a temporary sprinkler system. So Vanguard is in this all the way. They directed where to place the markings, and Vanguard is your contractor.
Yes, and the accident wouldn't have happened had Real Plumbing marked the correct area, and
Vanguard told him to mark the correct area.
and Zarem for cutting the power. The purchase order on the record of...
Sounds like you're all in it together, right?
Well, the purchase order on 762 on the record, it says that Zarem is required to provide all disconnects and safe offs for removal by others. And Zarem was the only electrician on site, and plaintiff had testified that Zarem was working in the same places we were working and made sure that everything was ready for the demo crew to go forward, and Zarem failed to do that.
Thank you. You'll have time on rebuttal. Okay, who's next?
Adam Hurwitz of the Perisman firm on behalf of the plaintiff respondent. Good afternoon, good late afternoon, Your Honors. First, the lower court did grant plaintiff summary judgment on 241-6 for the violation of two particular regulations, 1.13b3 and 1.13b4. And there's no question, nor has it been argued in the briefs, that these violations did not occur. I think Your Honor said it best. The owner here cannot pass the buck, yet they haven't tried to do so. In three specific ways. One, they claim that in effect they had policies and procedures by which the GC or some other contractor on site needed to send written confirmation or written request to turn off the power. The violations, the regulations that were violated don't speak about policy or procedure, they speak about action. B3, investigate and warn, that was not done. B4, turn off the power. And we know the power wasn't turned off because my client unfortunately sustained serious second and third degree burns when he cut into that bus duct that he was directed by Mr. DiGrigoli to cut into. They also claim that they didn't have notice, and clearly under several cases, notice is not an issue to affect liability under 241(6), as long as there is someone in the chain of construction that is determined to have been negligent. And here, no one disputes that somebody was negligent, whether it be Vanguard, whether it be Zerum, or whether it be Real Plumbing.
So what do you do with the statements that are made again and again and again? I didn't know it was there. I didn't know, once I knew it was there and what had happened, I didn't even know what it was. What do you do with that statement, which is attributable to Vanguard and to R Plumbing and to Zerum?
Well, if any of the parties, particularly the owner and or Vanguard, can avoid responsibility by simply saying, we didn't know, it's not a matter of notice. They had the obligation. The owner had the non-delegable obligation and duty to know, whatever that entailed, whatever that required. And they failed in all respects to do that. One last thing, unless there's questions about the granting of summary judgment or the dismissal or the denial of summary judgment to the defendants in the lower court. The issue of affirmative defenses. I see my time's up. May I just have one more minute?
Sure.
Okay. The court dismissed all affirmative defenses of culpable conduct. That issue has not been briefed or raised in any of the appellant's briefs here, and I would.
It's not an issue.
It is not an issue. Thank you, Your Honor.
Thank you. You may proceed.
Good afternoon, Your Honors. I'm Richard Ashnault from the law offices of Kevin Westerman for third-party defendant respondent Real Plumbing. There's an issue about, there was a question about the marking. The record makes fairly clear that Real Plumbing's foreman at one point had suggested using existing Kindorf to hang the temporary sprinkler.
Sorry, an existing what?
Kindorf, which is, they're hangers, basically pipe hangers that are already in the ceiling that were being used for something else. And the building superintendent as well as Vanguard's project manager basically said, no, you can't do that. You have to put new Kindorf in. So go mark where your Kindorf has to go, and then we'll take everything out that's in your way. So the only thing that Real Plumbing did here was actually mark the floor, not the ceiling. They marked on the floor how far away all the different hangers had to go, then left, and then the plaintiff and Vanguard went in and took everything out. The 1.13 industrial code section on which the lower court's decision was based puts the impetus, the responsibility for determining the location and whether or not there is live electric in the area on the employer. That was not Real Plumbing here. It was Vanguard. Vanguard had the responsibility to find out and the obligation to find out whether there was live electric in the area, and the regulation actually says something to the effect of visible or not visible. They have to determine what is there.
Plumbers are keenly let me change that. Plumbers are keenly aware of the interaction between plumbing and electricity, right? More than anybody else, because there's such a danger with the interactions. So did your client have an affirmative duty to ascertain where the hazardous points were in the ceiling? Or can your client simply say, I didn't know, I just marked, I didn't know what was going on?
Well, demolition and electric were both expressly excluded from the purchase order under which Real Plumbing was doing their work.
Which means what?
Which means what? There is no affirmative duty. No, they had actually had it was written into their contract that they did not have a duty. And plus, given the provisions of the industrial code the industrial code sections that are being relied on here, it's the employer's responsibility to do that. And this did not involve Real Plumbing's work directly. It has, at best, a tangential application to Real Plumbing's work. And this court, as indicated in our brief, has held that there has to be more than just this peripheral connection to the work in order to trigger the indemnity clause. And just one other issue real quickly, I know my time's up here. There was the issue of the insurance procurement. Our insurance policy was annexed as Exhibit B to our papers below. At record page 1268, there's an automatic status for additional insured when required by contract. So obviously that was established as well.
Thank you.
Thank you.
You have a minute.
Thank you. I just want to briefly address a couple of things. First, as my adversary or my colleague just said, the responsibility was Vanguard's. After it was determined that these items were going to be removed from the ceiling, Vanguard needed to pause and determine what they were removing and what they were directing the plaintiff to remove. They didn't do that. Things were marked, and the plaintiff was immediately directed to go up and start cutting. No one approached Zerum to find out what they were cutting or to confirm whether or not anything in there was electrical. All of the other electric on the floor, it is undisputed, was off. The only light and power was the temporary light and power. Plaintiff testified to that. It's undisputed. The only other thing I'd like to address, because it was not addressed in the decision below, despite that it was part of our motion, is the summary judgment on on the claims for contractual indemnification and procurement of insurance. Even if we assume, for the purpose of this argument, that the purchase order was in effect, there is no indemnification requirement. Counsel acknowledges that throughout the brief, yet it was not addressed in the motion. And similarly, there is nothing in this purchase order that required my client to procure additional insured coverage for the owner or anyone else. So those claims minimally should have been dismissed. Thank you.
Thank you. Have a good evening, all. Skyview Capital versus Conduent Bus Services.
Good afternoon, Your
Business
Honors.
Services.
I'd ask the court's permission for Fred Rowley Jr. to argue pro hoc vice for defendant appellant here.
Application granted, and welcome. Okay.
Good afternoon, Your Honor.
Good afternoon.
May it please the court, Fred Rowley Jr. for Conduent Business Services. We've raised a number of issues, but I'd like to focus on the motion court's denial of summary judgment on Skyview's fraud claim. New York law makes clear that a sophisticated company like Skyview Capital cannot get out of its contractual obligations by merely claiming fraud after the fact. When a sophisticated buyer wants to acquire a business, New York imposes on that buyer a duty to investigate the business and to conduct reasonable diligence. New York imposes these requirements on sophisticated buyers.
So tell me, how could Skyview have discovered through reasonable due diligence all of the things that your client was deliberately trying to prevent them from finding out? Deliberately.
So, Your Honor,
we have a bunch of emails. Don't smile at me like you don't know what I'm talking about. Deliberately. Before I answer that email, what did you tell him to make sure I don't tell him anything more than you've already given him? Stuff like that. So tell me, because at the end of the day, the issue is that, right? Could they have discovered what they're complaining about
Yes, Your
through
Honor.
the exercise of reasonable due diligence? So tell me, how could they have discovered the things that your clients were purposely trying to hide?
So Your Honor, we submit that the undisputed facts show that we actually did disclose those things, but I want to answer.
I know about the data server where you would dump items and throw them in there into this virtual data room, hoping that, by the time they find it, it'll be too late. I got that. But tell me how they could have, other than the data dump, tell me how they could have found out about all these things.
So Your Honor, there are three separate fraud theories. There are three types of information that are the basis of the fraud claim. The first is financial projections. The idea was that Conduent provided Skyview with a management presentation in July 2018 that had certain projections.
And which from the very beginning were not truthful, but go ahead.
So, Your Honor, Skyview doesn't challenge those projections, but the point that they're making is, well, there were these internal projections, and those weren't disclosed. First, they were disclosed in the September management presentation. So that's the first point. But more importantly, it matters a lot what we're talking about. What's the kind of information that was allegedly concealed? And here we're talking about financial projections. This is a corporate acquisition.
Not just financial projections, right?
Your Honor,
it's also about the bodies that would be replaced in positions so that the company that they were acquiring could actually even approach to meeting those projections. They needed the actual employees to do the work, and that was being hidden from them too.
So, Your Honor, with respect to the reductions in force and the number of recruiters, there's a separate problem with that claim, and the problem is that they contractually agreed to the final number of recruiters. In the TSA, they agreed to 38 recruiters. So there's just a contract bar to that fraud claim. Particularly a sophisticated buyer can't say that they were denied information that is in the contract. So there's a separate problem with that theory. But I come back to the financial projections, because this was really the focus of Skyview's arguments below. And it matters so much that these are the kinds of information that corporations generate all the time. And that's why New York, in cases like HSH and in cases like Global Minerals, why New York law requires you to ask if what you want is internal analyses of the business, because these get generated all the time. They're fluid. And so a reasonable buyer asks. Now, I want to get to Your Honor's question about this, because
Was there anything inside that September agreement that required Conduit to give the buyer notice as soon as they became aware of any occurrence of material adverse effect, or does that not apply to whatever Skyview is claiming?
So, Your Honor, that does apply, because, as we argued below, and as the motion court considered and found with respect to the advertising-based fraud theory, there's duplication here. The same grounds for fraud with respect to the reduction in the number of recruiters, and with respect to the court found with respect to advertising, but also with respect to the Sprint repatriation scheme. This is the 150 jobs. Right. Yeah. Those are also asserted as grounds for breach of contract. So on that ground alone, and in particular, the material adverse event, that theory makes the fraud claim redundant.
Right, duplicative of the contract claim.
That's right, Your Honor. And so back to quickly with respect to the financial projections, I would also note with respect to that theory, but also the Sprint repatriation theory, that these are statements of prediction. They're projections. And on that ground alone, the kind of information...
Except that the numbers of the workforce,
yes, Your Honor,
were absolutely, inextricably linked to the performance, the projected performance. You can't get, again, they can't get to the projected performance numbers without the bodies to do the work. So one absolutely impacted the other.
Your Honor, again, but that number of recruiters, which Skyview says is very important, it's in the contract. They agreed to 38 recruiters in connection with the TSA, and for that reason, they can't argue that they're...
I must say that your arguments just come across to me anyway as disingenuous. You were trying to sell not you, your client was trying to sell a product, and the emails show again and again and again that there was a concern that if anybody saw the real picture, they weren't going to pay that dollar amount or maybe not pay anything at all. Maybe they would just walk away. How do you not call this deception? How do you not call this breach of contract? Where do we go with this?
So, Your Honor, if you look at each of their fraud theories, there's 3 of them. There's independent legal bars as to all of them. So with respect, again, to the projections, they were updated in September 2018.
Yeah, but then they said, we're not going to update it anymore because it might affect the numbers.
Your Honor, they got actual financials before the final agreement was signed. So they even got actual financial records and financial data for fiscal year 2018 before they signed the contract. So there were updated numbers that were provided to Skyview in September 2018, and then they got the actual numbers. With respect to the Sprint repatriation scheme, I would note again that on November 7th, Mr. Kinnick told Skyview that Sprint was going to reduced headcount by 150. Now Skyview says, well, that's a different reduction. It happens to be a different reduction in 150 seats. But the point is, if a reasonable buyer is told this important client, which they argue is down 150 seats, you should ask, well, is it this 150 seats? Is it another 150 seats?
Okay. You'll have time on rebuttal.
Thank you, Your Honor.
Thank you, Your Honor. Matt Adler for Skyview. Many hours ago, and it's been a fascinating afternoon, I'm grateful for the proclamation. Your Honor said a picture is worth 1,000 words, and we were also admonished not to talk too much about the record, but there's a picture that is worth 1,000 words that I think answers so much about the court's questions. And it's the snapshot that they did. It's the record at 7856. These are all the defendant's words, and it's an amazing document because it takes the management presentation that was done during the courtship period when they were looking for buyers for this business. That's the left column. And then in the middle, it says forecast in VDR. We used to call it the war room when I was a kid, but that's the virtual data room where all the documents go. And then it's extraordinary. In the third column, it's Q3 reforecast. It's what they didn't put in the VDR room.
But then, when you get to the actual contract, Skyview represents that it made its own evaluation of the accuracy of all estimates, projections, and forecasts furnished to it. Why isn't that disclaimer specific enough to defeat your claim?
Because Skyview, Your Honor, is not suing on the basis of the inaccuracy of what was delivered to it. The fraud is the material omission of what was not delivered to it. Had they produced 8, 8, and 6 as revenue projections, and then the revenue came out at 5 the first year, we could have never said, and we do not say here, your projections were wrong. That's not the fraud case. The fraud case, to answer Your Honor's question, yes, my client did some investigation. Yes, my client's sophisticated, but it was not given everything to form that sophistication. This was a material omission.
No, but it's the sophistication that is supposed to alert you that something is missing, right? So you have to ask questions. So how is it that your client is told that Sprint's numbers are going down so significantly, and there's not greater dialogue and questioning about that?
There was dialogue and questioning. The record reflects that there was talk about Sprint, and the talk was about this contract and that
So
contract.
you met with Sprint. Why didn't you ask Sprint questions? Didn't you meet with Sprint?
The client did meet with Sprint.
You get information, due diligence, Sprint, what's going on?
I understand that, Your Honor, but the discussion with Sprint was based on what the seller was saying to Skyview. Skyview then did its own investigation. It was charged with it. I do want to answer the court's question.
Right, but getting to what my colleague just said, if Conduit said one thing and you have Sprint in front of you, this is what better place and time to confirm the information than right there?
Because it was never disclosed to Skyview, the repatriation part of Sprint. There are two different aspects to Sprint. Is Sprint business going down? That was disclosed, and yes, Your Honor, discussed with Sprint. But the repatriation part, the seller, Conduit, hid, and we never got a chance to ask that. There were two different parts. They always mask what we're talking about with Sprint. There's no doubt the Sprint
But
business
that repatriation issue, was that solely in Conduit's knowledge, or did Sprint also know that?
Well, I can't speak for Sprint. I think a fair inference is that Sprint would know that.
Right. And so then to take that point to its logical conclusion, you could still have asked Sprint that question
We could Skyview have asked Sprint that
as
question?
part of your due diligence.
Yes.
To confirm all of the representations made by Conduit, it seems to me that would have been the perfect place to do it with the I don't know what you call Sprint from your perspective.
A big customer.
Huh?
A big customer?
All right, so this is a huge, like a Class A tenant, right? So this is a huge customer. Why would you not confirm that all of it's part of the key of the forecast, right? And this is where you can confirm that. It's your obligation to do that.
I would make one other point as to the facts to answer that question.
Okay.
There's a timeline here. The drips and drabs that came out of Conduit, and the particular Sprint drips and drabs that the court is questioning me about right now, was November of 2018. That was after the courtship period. That was after the contract was signed. So it was.
Counsel, now that you mentioned the contract, Section 915, the last section before the signature, reads as follows. Buyer acknowledges that except as otherwise specifically provided in this agreement, seller has not made any representation or warranties regarding the assets. You sign that. You don't speak to Sprint. You're a sophisticated party. They're telling you one thing. You have the best customer, Sprint, with you. You have a contact there. You easily could have just said, they're telling us this. What can we do here for you?
They were telling us as to different aspects of the Sprint business declining. They were not telling us as to repatriation. But I take the court's point. But what I wanted to stress earlier in my answer to Your Honor was, well,
It's okay, I'm smiling nicely.
Okay. I've been watching counsel just get creamed for 2 hours.
I'm sorry that you feel this way. We don't want to.
No,
we were all lawyers. I want you to know that.
We've been working on this for 4 years. We want to answer your questions. Your Honor, they were trying to sell this business badly. Everyone ducked out. They called my client. They begged it to come back to the table. It came back to the table, but we said, if we're going to come back to the table and we're going to sign this quickly, you've got to be very forthcoming with us. They then signed in September.
Was it really
Wait
that?
a minute. What have you paid here? What has Skyview paid? Have you paid anything here?
Recently, there was a payment. That's not in the record.
I'm sorry.
Oh, I was trying to. My point is simply, I'm getting lost as to the timeline. The disclosures came out in the drips or drabs after the contract was signed, after the courtship was done. All of the other, and you saw it, you were questioning the counsel about it. All of the other, we got to hide this, was let's get him to the table, let's get him to sign, because no one's buying this white elephant, and it's going to cost us $112 million if we
I think
can't
both
sell it.
sides are a little. Wasn't there something on your side about let's have a party, boys' night? You know, we're gonna get it all. We're getting over them. Jaffer is begging for mercy.
It was a bad word. And you can assume that client was counseled on it by me, but that's not in the record. But here's the point. Let's
We appreciate
contextualize
that.
that comment. That was in January after a particular, it's the reason there's actually a second amended asset purchase agreement. There was $8 million that should have come to my client in revenues. There was a face-off about that. And that's when Mr. Sultani, they won that. My client won that face-off. The extra $8 million came. It was a contextualized, I don't justify the word, but it was in a context of a particular $8 million face down that's otherwise not before this court.
Okay.
Can I? Yeah, I'm stopping on my head.
Okay.
A couple of points, Your Honors. So, on the Sprint repatriation, my friend referenced the timeline. I do think the timeline's important because the only record in the evidence about when Conduent learned that Sprint had changed its mind, it's not going to bring back these 150 jobs to the U.S., was on November 7th, Kinnick sends an email to Skyview. Kinnick's at Conduent, then he goes to Skyview later, and he says, Sprint reduced headcount by 150. And actually, there was an earlier email. There's an earlier email from Kinnick that says, it's actually not, I apologize, it's Kinnick's testimony. It's his testimony. And he says that Sprint emailed Conduent, and I'm quoting here, in or around November, advising him, and that's a Conduent manager, that they had changed their repatriate, and it goes on. So the only evidence is that
Doesn't Kinnick also email if this isn't a material adverse breach that we should tell them? I don't know what is.
well, so, but, Your Honor, I guess, again, the point is, just to finish this point, because it is important, there isn't any evidence that shows that this representation that was purportedly made about the jobs coming back, that could have even induced the initial purchase agreement, because this evidence is in November. The purchase agreement is signed in September. But the more important point is the one that Your Honor referenced in your questioning, and that is that if this is a big client, big customer, and you learn you're 150 jobs down, you ask about it. You're already in direct communication with them. There's a 4-month diligence period. You've got plenty of time. You've got lawyers, you've got bankers, and what New York says is you ought to ask about that. So that's the first point. The second point is I want to refer to what Your Honor asked about the terms of the contract. Because one of the things that the court mentioned in an earlier argument is that parties are entitled to chart their contractual course. And in this case, there's disclaimer after disclaimer in the purchase agreement. And they signed those disclaimers not just once, but twice. In the initial purchase agreement in September, and then again in the final purchase agreement. The last thing I'd like to say is, because my friend did refer to a chart about the financial projections. And if you look at page 20 to 21 of our reply brief, we explained there why the September management presentation did provide updated information and updated projections, including $8 million reduction in Sprint revenues, in a $6 million for Sprint and $8 million for reduced Cox revenues.
When was that? When was that provided?
That was provided in September, Your Honor. And those are based on August projections. So those August projections, they superseded the July projections. And so the record makes clear that they got updated projections. And in that respect, there just was no concealment at all.
When you're speaking of the September, November timeline, the November timeline that you're speaking of is before the Second Amendment, so Second Amended agreement was entered into?
You mean, did November precede the?
Yes.
It did, Your Honor. So there was a 4-month diligence period. The initial.
So then in November, when this information came to light, was there any duty at that point to disclose before this Second Amended agreement was entered into?
So are we talking
About the repatriation?
Yeah.
Oh, about the repatriation? So we submit that there was information about the Sprint reduction in jobs that was disclosed. And this is what the email says. It says, Sprint reduced headcount by 150. So that email, which is sent on November 7th, 2018, we submit provides adequate notice to a sophisticated buyer that if they're worried about this, they are already talking to Sprint, they ought to ask. And I think cases like HSH and Global Minerals makes that abundantly clear.
Thank you. You have 2 minutes.
Again, I'd like to make 4 points. First, as to the September.
So you got 30 seconds for each.
Now we have 27. As to the September management presentation, that's a sharply disputed issue of fact. I'd refer the court to page 15 and pages 29 and 30 of our opening brief. They were not updated figures, and in fact, the motion court called that a sleight of hand, that argument. That's factual. Secondly, as to the whole sophisticated party thing, yes, the contract said what it said, but there's a whole New York law of fraud that I'm not purporting to instruct this court on. There's a peculiar knowledge doctrine that the motion court applied. There is a two-part test on that peculiar knowledge doctrine, and they failed both parts of it. The notion that fraud claims can't coexist with contract claims is not, as I understand it, New York law. And in fact, the motion court did a very good job of articulating when it is and is not duplicative, because he bounced the advertising claim because that he didn't find a statement of present intention, but he kept the claims on riffs and on management presentations. So that the two can coexist. And then finally, because there's not otherwise been discussion of it, but this is our appeal, the motion judge actually said, I would be happy if you would take this back to the First Department. And it's our contention that the Parlux case should not preclude our argument that the judgment here be set off until there's a final ruling on the fraud claim, because it's our contention that Parlux is distinguishable. The motion court had gotten reversed on Parlux, but he said, please take this back because Parlux was two contract claims setting off. This is a fraud claim setting off a contract claim, and we would urge this court that the equitable result is that you should look, please, at whether you want to extend Parlux to mixed fraud and contract. I am out of breath and time, and I thank this court very much for its attention.
Thank you.
Enjoyed you. Thank you.
Nope. No, sir, reply. Have a good night, lady and gentlemen. Anheuser-Busch versus BBSR LLC. Stand up.
They're tired just watching us. Look at them, they look exhausted.
They've been here all day.
Okay.
Good afternoon.
Last but not least.
Thank you. May it please the court, my name is Jordana Haviv, on behalf of Appellant BBSR. We're before the court today on a straightforward question of whether Supreme Court erred in applying the federal apex doctrine, which limits depositions of senior.
Can you bring the mic closer to you?
Sure, sorry. How's that?
Yes.
We're before the court today on a straightforward question of whether Supreme Court erred in applying the federal apex doctrine, which limits depositions of senior corporate executives. As a matter of law, controlling precedent in this state conflicts with the apex doctrine. The apex doctrine is a federal doctrine that shields corporate executives from depositions unless the executive has unique evidence, personal knowledge of the claims at issue, and other witnesses are incapable of providing testimony about the conduct alleged. But that's not the law in this state. Indeed, Anheuser-Busch readily concedes that New York state courts do not use the term apex. And Anheuser-Busch has failed to identify a single instance in which a New York state court applied the apex doctrine to quash a subpoena following Capone.
Is the information that this particular witness has relevant to the issues that are being litigated in this matter?
Yes, it's absolutely.
How so?
So Mr. Mercondes was the chief marketing officer. He was the person who was responsible above another individual who had admittedly the day-to-day management, but he was her supervisor. So he was responsible for what she was doing, and he had to align with her decisions.
Did he have to approve the decisions that she made?
He had to, what's called in Anheuser-Busch's language, align, which means not necessarily agree, but allow her to proceed with her decision. So for example, it would be highly relevant to our case if she wanted to, say, replace the name with Bon and Viv, and he said, oh, I think that's a terrible idea. It would destroy all the brand equity. We're not, of course, saying he would say that, but it would matter to our case what his views were, and that's
so he could overrule her and say, no, you're not doing that.
He could say, yes, I'm not aligned, and we won't proceed that way.
Or he can take a deposition and tell us that he couldn't.
That would also be possible, Your Honor. So the leading case, Capone versus Koch, sets out the binding three-part test. I'm not going to go into that. It's in our briefing why it's easily met here. And one of the main reasons why his testimony is so relevant and why we feel it's critical to get his deposition before trial proceeds in July is that a central issue in the underlying litigation is whether Bon and Viv was a Boathouse product or whether it was something else, a new product. So therefore, whether it was either an evolution of the existing Spike Seltzer brand or whether it was a new brand, a competing brand, bears heavily on that central question. And Mr. Marcondes' views about that topic are highly relevant as the chief marketing officer. And indeed, in one of his emails, he referred to Bon and Viv as a, quote, new brand from scratch. Now, that statement directly undermines every argument that Anheuser-Busch has made in the underlying litigation. They say it's not a new brand, it's an evolution, they look the same, they have the same marketing, they have the same features. So that would be highly relevant. There are other reasons why his testimony is relevant, but to us, that's the chief one, and that speaks directly to why we need his testimony. And Ms. Phillips could not testify as to what he thought. We directly asked her the question. We said, do you know if he thought it was a new brand? She didn't know. And of course, there's the requirement that we discussed, that he concur on the major strategic decisions.
What did she say that regarding that? Did she think that it was a new brand, or?
She does not think it's a new brand. She believes it to be an evolution of the new product. So she supports Anheuser-Busch's litigation position, which of course is why that makes that testimony all the more relevant. If her superior had a different view, but nonetheless aligned to her vision, allowed her to proceed with that vision that it was an evolution, that would be relevant to our litigation position.
Thank you. You'll have time on rebuttal.
Thank you very much.
Thank you, Your Honor. Appreciate your indulgence. I know it's late in the day. This court has consistently said that they are not going to second-guess trial judges' decisions on discovery disputes.
But, counsel, before we get to that, because yes, this court, that could be the thought of this court. Do you have any cases where the Court of Appeals or this court has applied the Apex Doctrine?
Yes, yes, and
after 2014?
Yes.
Okay.
Because
that was the Capone case?
Yes, no,
All
thank
right.
you, Your Honor. Let me get right to that. And the appellant had no answer below to this. This court, in the Gross case, in 2022, 8 years after Capon, applied the unique knowledge standard that is referred to as Apex in federal court.
It also applied the utterly irrelevant standard, and then it went on to discuss the unique knowledge standard, which is not to say that it only applied. I mean, that's because I got the case here too.
No, Your Honor, but the point is that unique knowledge standard that is referred to in federal court as the Apex Doctrine is applied in New York and has been applied post-Capon. And I will tell you something, Your Honors. They don't deal with Gross in their brief. They don't get to it until a footnote on the second to last page. And what do they say? They say, to be clear, appellant's position is that the court, that would be you, misapplied Capon by invoking the unique knowledge standard that Capon effectively abrogated in the Gross case. And Your Honor, here's the problem. This court apparently made the same mistake again 6 weeks ago. We have found, since we filed our brief, that in a case, CK Opportunities Fund versus Morgan Stanley.
Right, I have that case as well.
Again,
it's the same kind of situation, but could it be that maybe in making those two particular rulings, the court is setting forth or reaffirming Capon and saying, yes, this is the standard that we follow, the utterly irrelevant standard. And even if we were to look underneath the Apex standard, then the discovery should still take place.
Your Honor, that's not the language that the First Department used in either one of those cases. The First Department applied those principles. Now, the First Department
you realize we have thousands of discovery cases.
Yes.
And if you can only cite 2 cases where Apex appears, because I've been here 15 years, and it's the first time this argument has been made,
Your Honor.
okay? So
Your Honor, it's not.
how is it utterly irrelevant? Why don't you tell me that? Because I'm not buying this other argument.
Sure, Your Honor. We know what the decisions were that were made. I hate to sound like a broken record because I was going to reference Judge Mendez's comment at the beginning of the day about a picture is worth 1,000 words, and then the last lawyer stole the line. But if you go to the supplemental record on pages 16 and 17, the pictures of the cans at issues are there. Those cans were shown to Judge Tisch below. And Judge Tisch viewed the cans. He also determined that this deposition was not necessary because they deposed the decision maker here, Ms. Phillips, who is herself a senior executive, for 10 hours. They deposed the CEO of the company. They deposed 10 other people. They got hundreds of thousands of documents. And as Judge Tisch said below, whether or not Mr. Marcondes aligned to decisions that Ms. Phillips made was not relevant, was not necessary, and didn't satisfy CPLR 3101, not to mention CPLR 3103, which gives the court the ability to enter protective orders to protect people from undue harassment.
Thank you.
Thank you, Your Honor.
You have 1 minute.
Thank you, members of the panel. I'll be very brief. I think you understand our legal position. Gross did not apply the unique knowledge standard, and it didn't quash the subpoena, and it obviously permitted it to go forward there. I'll just speak very quickly to the cans. That's not really at issue on this motion. The underlying court has denied summary judgment on the contract claim. The case is moving to trial.
Looking at the cans doesn't tell us anything.
That is what he did not find it to be dispositive, at least. Thank you very much, unless there are further questions.